Salute, shout out to everybody in the building, man. Make sure y'all double tapping that screen. This is Tyler Robinson, guys, live in court. The accused unaliver of Charlie Kirk. What's up with it? So blessed. Shout out to you for being a member for 18 months. So we waiting on court to assemble, guys. Here in a couple seconds, you will be hearing the proceedings of what's going on with Tyler Robinson. Remember, it was a big discrepancy about the weapon used to unalive Charlie Kirk. It's been a lot of back and forth about that. So here for Tyler Robinson, guys. This is live.
Not terribly long.
Yeah.
But
You're going to call your investigator, right? Yeah. If you want to put the report in, that's fine. Somebody want to do it.
okay, that's helpful. Thank you. That's cool. Actually, that's not.
What you got going, Bless? What's up with you?
We have so think about it.
Say she chilling. What's up, y'all? What's up, West Side? I might have went live too many times last night. They might not even sent out my notification.
All right.
Court is now in session, guys.
Please be seated. Good morning. It just take me a moment to set up a couple things here. Appreciate your patience.
We're on the vertical, guys.
All right, court is now in session. Video recording may begin. Calling case number 251501576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Chad Grunander, Lauren Hunt, Ryan McBride, and Chris Ballard for the state here in the court today, Your Honor. County Attorney Jeff Gray is joining via WebEx, although I don't believe he will be making an appearance at today's hearing.
All right, thank you and good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who is seated beside me.
Good morning to Defense Counsel. Mr. Robinson, good morning to you as well. All right, before addressing the business that's before the court today, I want to address some preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during these proceedings will not be permitted to re-enter until the recess. So I just want to give you that heads up. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, I wish to address the camera operator and still photographer, if you would both come forward. All right, so I don't mean to cause you any discomfort, but I just want to ensure the expectations of how we're proceeding today. Could you state your names and your respective roles?
Bless. Y'all come to the vertical live.
Pool photographer for the
Finna try to end this.
Mr. Nelson.
Adam Fonder and video pool for ABC4.
Thank you. All right. Have you both reviewed the court's standing decorum order dated February 24th, 2026?
Yes. Yes, Your Honor.
And do you understand the requirements set forth in that order as it applies to your activities today?
Yes, Your Honor.
All right. Do you require additional time to review the order or to adjust equipment to ensure compliance?
No, Your Honor.
All right. Do you anticipate any difficulty with complying with the order?
No.
All right. Well, Mr. Nelson, Mr. Fondren, I appreciate your cooperation. Thank you. Turning next to discovery, counsel for the state, could you give an update?
Your Honor, on April 3rd, I filed a notice of the state of discovery with the court. I don't know if you've seen that, but I attached to that filing a 225-page document that lists the discovery that has been provided as of April 1st of this year. There's over 20,000 files. That document has about 100 files per page listed. Discovery continues to come in. I believe it was March 26th, Defense Counsel sent a discovery letter requesting special discovery or specific discovery of materials, case files, underlying data, and so forth of lab materials from scientific reports. We're going to address some of that in the motion to continue the preliminary hearing today. Those materials have been requested from the FBI and ATF labs. Both laboratories are responding to that. They're reviewing it and they're providing information. As of Saturday and Sunday of this week, ATF, or some weeks ago, ATF provided to SBI their entire lab files, their entire case file. On Saturday and Sunday of this week, SBI was able to process much of that material, and we were provided at our office about 1,700 files from the scientific reports from the ATF. Just last night, I was updated that we received some more of those files, and that discovery continues. We're processing that material, bait stamping, cross-checking for duplication, and then providing those materials as efficiently as we can.
Thank you, Mr. McBride. Appreciate that update. All right. The court will now, and to the other parties, did you want to weigh in or comment on that?
Thank you, Your Honor. Richard Novak for Mr. Robinson. I think the status of the specific items of discovery that Mr. McBride was just mentioning is sort of the core of the present dispute about whether the preliminary hearing can go forward in mid-May. So I guess the best thing to do would be to reserve comments about that until the court wants to take up that motion.
Thank you, Mr. Novak. I appreciate your input on that. Well, turning to that, I do want to outline the procedure for today's hearing, and it's to do so in an orderly and efficient presentation of the issues before the court. First, we'll be addressing the motion to continue the preliminary hearing, which is set for next month. And what I want to do is I'm trying to manage time as at the same time allowing all parties the ability to present what is necessary in order for this court to make a well-informed decision. And so here's where I'm landing. As it relates to the continuation of the preliminary hearing, I will allow both sides 30 minutes to present what you wish to present to this court. This would include any allocation for rebuttal for defense. Upon conclusion of argument on that motion, the court will proceed to the pending motions concerning media access within the courtroom. Each side will be afforded up to 2 hours to present argument, examine witnesses, cross-examination, and redirect, and respond to inquiries from the court, as well as reserve time for rebuttal. So I just want to create that expectation. Knowing the expertise and experience of the parties, that's probably more time than you need, but I want to create an expectation so we know how to proceed. I encourage the parties.
Thank you for the gift.
In presenting the evidence and purposes of these time allocations is for case management and not to alter or diminish any of the parties' substantial rights. Following the defense's presentation, the court will recess for approximately 30 minutes, during which time the courtroom will be closed. Proceedings will then resume with the state's presentation. If necessary, members of the media will be thereafter afforded up to 15 minutes for any responses. The court will then take a brief recess of approximately 10 minutes. Upon reconvening, the parties may proceed with closing arguments using any of the remaining allotted time. The court will monitor the time and argument will conclude upon the expiration of that time. The court anticipates issuing its ruling at a later time via WebEx, as you may come to expect, to permit full and careful consideration of the record and the arguments presented today. The scheduling of that proceeding will be addressed at the conclusion of today's hearing. The court recognizes the significance of the matters before it and the preparation undertaken by all counsel. All participants are expected to adhere to the applicable standards of professionalism, civility, and ethics. The court finds most helpful those submissions and arguments grounded in the evidentiary record and supported by controlling authority and applicable law. Counsel are expected to ensure that their witnesses conduct themselves in a manner consistent with these standards. The court will now turn to the defense. Mr. Novak.
Thank you, Your Honor.
Hey, amazing.
Novak for Mr. Robinson. Your Honor, the three docketed pleadings that are germane to the defense's first motion to continue the preliminary hearing are our motion, which is docket number 466, state's response, which is docket number 476, and our reply, which is docket number 493. I can keep track of my own time, but my expectation is that I won't need all 30 minutes, but whatever I don't use, we'll see if any rebuttal is necessary.
Thank you.
So I think, if I may, the last time we were here and there was sort of a preliminary discussion about the May setting for the preliminary hearing, I think I said to the court, I don't need to reiterate what the court said to us when it set the date. But I do think, in light of the status of specific items of discovery, which I will get to, and the state's position on whether the preliminary hearing can go forward, I do want it to be clear, at least for the record, because I obviously understand that Your Honor knows what the court said, that the expression of the court back in December was that no party would be prejudiced by this setting. And I think that's important because when we look at the status of discovery with respect to the specific scientific evidence we're talking about, and we look at Article 1, Section 12 of the Utah Constitution, and we look at Rule 16, and we look at Evidence Code Section 1102, it is clear that Mr. Robinson is prejudiced by the preliminary hearing going forward as scheduled at this point. And it can't even be remedied in the next 4 weeks. I very much appreciate the update that Mr. McBride provided. He actually provided that to us before the hearing. But the bottom line is that we don't have from the prosecution team, and I'm going to explain what I think the prosecution team means in this context, data which is in their possession, which is clearly discoverable under Rule 16, which is what the Constitution of Utah refers to when it talks about appropriate discovery. And that brings up the reliability question under Evidence Code Section 1102. So there is no doubt that the ATF and the FBI have data files that represent what I'll call the digitization.
Thank you amazingly. Y'all make sure y'all double tapping that screen, guys. This is how you hit the like button. This is Charlie Kirk's alleged unaliver live in court, guys. This is live.
Criminal Procedure Rule 16A1C. And then when it's digitized, and it may be that experts will tell me that's not the right word, but when it is converted into data that can be analyzed, data sets that can be utilized in DNA analysis, that's electronic evidence under Rule 16A1C. And we don't have that, and Mr. McBride acknowledges that we don't have that. And when I say we, I mean the defense, from either the ATF or the FBI. Now, Mr. McBride, I think, said to the court, he did say to me, that the ATF has just recently given SBI some files. SBI has turned over some of them to the Utah County Attorney's Office, but not all of them. The defense has not yet received them. So neither Mr. McBride nor I actually know if these data files, the raw data upon which all DNA analysis has been done, or have been produced from the ATF to SBI, and we don't know if it's gone from SBI yet to the Utah County Attorney's Office. The FBI has not turned over anything, according to Mr. McBride, that might include the data files, because there has been no production by the FBI in recent months in what I'll call the DNA area. We did make what Mr. McBride called a supplemental discovery request some weeks ago that set forth with great specificity the forensic related documents and materials that we want, including those data files. That's actually attached as an exhibit to our motion. But that was not the first time that we asked for these data files. And I am not casting aspersions at Mr. McBride and his team, because those data files are in the possession of their federal law enforcement partners. We're not asking somebody to go looking for a needle in a haystack. Hey, there might be some piece of evidence somewhere. Can you go looking? We know that these data files exist because we have summary FBI and ATF reports summarizing the data analysis that go all the way back to September. So I actually think that one of the questions, if I may, one of the questions, because counsel don't ask each other questions in the courtroom. We understand that all questions are asked by the court. Why hasn't the FBI turned over these data yet? And why hasn't the ATF clearly communicated until very recently whether it has and why it has not? The state's opposition to our motion does not explain why the data files have not been turned over. So now what I want to talk about is the significance of the data files. We have a right at a preliminary hearing to both examine and cross-examine witnesses. And our right to present witnesses includes presenting expert witnesses. If the state doesn't want to call the forensic examiners at the FBI and the ATF to testify about their analyses and the conclusions, that's their choice. But we have a right to present evidence that gets at these DNA issues, and we have a right to do that through expert witnesses. We cannot do that when the law enforcement partners, ATF and FBI, have not provided us with appropriate discovery. That's the word, that's the phrase in the Constitution, appropriate discovery. So that appropriate discovery is the gateway to reliable hearsay at a prelim. It is meaningless for us to have the right under the code to present and cross-examine, present our own witnesses and cross-examine witnesses when we don't have the electronic evidence, that is these data files, that comes from physical evidence, the DNA swabs. It's a meaningless right, and it frankly makes a mockery of the reliability concept. We have identified for the court in public pleadings 2 DNA experts who we have retained who are waiting for these data and for other materials so that they can advise us on whether the opinions expressed in these reports, these are ATF and FBI forensic reports on the results of their DNA analysis, whether these reports are reliable. And if they are, if they're not, cannot be determined without that underlying data, those underlying data. So we have the experts, they're waiting for the data. We don't have the data. It's not Mr. McBride's fault. It's not SBI's fault. It's the law enforcement partners who have had these data files since September. Like, it's been over 6 months. And many of the DNA reports that they produce are also dated September. And I could go through each one of them if necessary, but maybe I'll do that in rebuttal because I don't want to run out of time. So we can't present any expert testimony on DNA without having the underlying data. Second step, if the state doesn't want to call the forensics examiners from the ATF and or the FBI as witnesses, we also have the right to call them as witnesses. We have a little bit of a jurisdictional problem because we're in state court and we're not in federal court. And so we have these 2 irregulations, which I'm sure the court is familiar with and are addressed in our reply brief. And I have personally been in contact with counsel for the ATF and counsel for the FBI who have not said, yes, we will make these witnesses available. They have said, why don't you get us some subpoenas, which are, by the way, not enforceable, but they're subpoenas. And could you give us a more definite statement of exactly what you want them to testify about? But I can't examine those witnesses without the data and without the data files being evaluated by our DNA experts. The state suggestion that we just put these reports in through Rule 1102 before really calls into question the concept of reliability, because there is no way for this court to evaluate the reliability of those conclusions. There is no adversarial testing if I don't have those data, if I haven't been able to give those data to our DNA experts, if they haven't been able to tell us what they think of the data vis-a-vis the conclusions in the reports. So we have a problem with adversarial testing. It's a critical stage of the proceeding. We are basically handcuffed under the state's proposal, which is the court receives.
Yeah, it's on
evidence
members only.
reports
Yes,
which
2008.
we
I did that
cannot
yesterday.
in any way address the reliability of. And so this actually goes all the way up to the Utah Constitution, which says that reliable hearsay is admissible if we have appropriate discovery. Appropriate discovery, again, is the constitutional phrase. But it also implicates, because it's a critical stage, Mr. Robinson's Sixth Amendment right. And as I addressed in our reply brief, the heightened reliability concerns that the Constitution reminds us of in any capital proceeding. And heightened reliability isn't just reserved for penalty phase. And I provided the court with a number of cases which talk about heightened reliability being something that is a gloss over the entire proceeding. So the court, in my opinion, needs to, and in light of the law here, needs to say to the state, I can't do the prelim until the defense has the data files in a reasonable period of time. When are we going to get the data files from the ATF and the FBI? And if Mr. McBride, given all of his due diligence, can only say to the court, I don't know, because the FBI hasn't told us when, and the FBI hasn't told us why, then we're just going to have to wait. We're not interested in postponing this for the sake of postponing this. We're interested in having a meaningful testing of expert reports, which the state wants the court to just receive into evidence under 1102b4. And that's not reliability. That's not reliability under the constitutional test, which requires appropriate discovery first. It's not reliability under the 5th, 6th, and 8th Amendments. And I'm not in the business of telling the prosecution in any jurisdiction how they should do their job. But the state chose to proceed by way of preliminary hearing instead of proceeding through a grand jury. And this is where we are. We have a right under the Constitution to have appropriate discovery before this court receives into evidence what the statute says is reliable hearsay. And if the court says, oh, you don't need the data files, then we believe that 1102b4 is unconstitutional, as applied in this case. If we have the data files and a meaningful time to evaluate them, then the state has fulfilled its obligations under the Constitution, and the reports can be received at least statutorily as reliable hearsay, subject to our right to present evidence through direct witnesses and through cross-examination. So I think other than what I've said so far, I would be repeating myself. And if I've not used my 30 minutes, then I'll save the remainder for rebuttal.
Thank you, Mr. Novak. Turning to the state.
Is that okay if I disconnect it?
Yeah, sure.
Trina, do you mind allowing me to present? Your Honor, the court should deny defendant's motion to continue the preliminary hearing simply because the reason the defense has requested to continue the preliminary hearing really has nothing to do with the preliminary hearing. It's unnecessary, the continuance is. It's necessary to expert discovery, it's necessary to expert notice, it's necessary to a 702 hearing, it's necessary to a trial determination of the weight to give to expert testimonies, but it is not necessary to a preliminary hearing. Now, before I jump into my argument, Your Honor, is my screen sharing? Yes, can you see it there, Your Honor, on your?
Well, let's see.
We're not seeing anything at council table.
I'm not sure if it's being presented yet.
Make sure I've got my settings ready too. Well, I'll assume that will come up as I'm talking, Your Honor. But before launching into my argument, I want you to understand my structure here, okay? My first point that I'm going to make is the defense has not shown that a continuance is necessary to the purpose of a preliminary hearing. Maybe necessary for other reasons, this material, but not necessary. Maybe this material and discovery of this material is necessary for other purposes, but not for the limited purpose of a preliminary hearing. And the second point is the rules don't require expert notice before the preliminary hearing. Look at Article 1, Section 12, Rule 16, Rule 7B, Rule 1102. They don't require expert notice before the preliminary hearing. Now, I want to start with that first point, which is the real standard, the salient principle from whether it's Longcrier or Lopez is you don't grant a continuance unnecessarily, right? Axiomatic, right? That's the salient principle from those cases. That's what common sense says. You don't unnecessarily continue a hearing, right? Why? Well, because it causes delay in the proceedings. In this circumstance, this is not a nominal delay. We're talking at least 6 months for the defense to get this material, review it, and consult their experts, and for their experts to be ready to present expert testimony. But more likely, even more than that, because there's litigation surrounding some of this expert investigation. One of the tests right now has not been performed because there's an objection to it. And we're waiting to litigate that issue, depending on what some of the experts.
Joe, a lot of people been saying that, man. A lot of people been saying that. You could be right.
Discovery request the defense has made and that they made on March 25th. So this is at least a 6-month delay, probably much longer than that, because some of these expert issues have to be litigated. And when you consider the purpose of the preliminary hearing, right, it's an initial stage of this process, right? It's designed to protect a defendant from having to sit in custody and wait for all the trial preparations.
This isn't the actual trial, Shira. This is like a pre-trial type thing.
The preliminary hearing is designed to ferret out groundless prosecutions. Probable cause is a very low standard. Reliable hearsay is admissible. The court doesn't weigh the evidence at this stage. And that's because this is a very early stage of the proceeding. And the rules contemplate discovery and investigation ongoing throughout and even past the preliminary hearing and even all the way up until trial. So the question is a continuance necessary for the purpose of a preliminary hearing? And to understand that, you have to understand two things. One, what is the purpose of the preliminary hearing? And two, what is the evidence that's likely to be presented at the preliminary hearing? And then you get to three, is a continuance necessary? First, the purpose of a preliminary hearing is clear. There's very few principles in Utah law that are more clear than this. There is one purpose to the preliminary hearing and one purpose only, and that is to determine probable cause. Every time a defendant or a trial court tries to expand the preliminary hearing beyond that, whether it's on constitutional due process grounds or discovery grounds or something else, the courts uniformly and repeatedly reject those arguments. There's only one purpose. It's clear in the Constitution. It is to determine probable cause. It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are, what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence, and it's certainly not a 702 hearing. It is only one thing, a probable cause hearing. That's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial, as well as the state's ability to present the case. Justice delayed is justice denied, as the saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial. Witnesses become unavailable, memories fade, evidence grows stale. And so the court should not be granting a motion to continue and delaying the proceedings unless it's necessary, especially for such a lengthy period. The next stage in understanding whether or not a continuance is necessary is, one, understanding the purpose, the limited purpose. Two is, what's the evidence going to be at the preliminary hearing, right? Because if you understand what the evidence is going to be, then you can determine, well, is what the defense wants to present, is that going to affect the probable cause determination, right? The only way to know that is to know kind of what the evidence is going to present. That's why Lopez says you listen to the evidence first, and then you should consider, in that case, whether or not the defense should be able to subpoena the victim. And I think the same analysis applies here. Listen to the evidence first, then you ask the defense, well, what are you going to present, and will it be necessary, will it be relevant to a probable cause determination or not? Put another way, will the defense be able to show that whatever evidence they want to present is likely to defeat probable cause? If they can't make that showing, it would be an unnecessary continuance. So let me give you a proffer of what the evidence will be at the preliminary hearing. There's really 4 categories of evidence. The first is surveillance from UVU. Now, UVU has a great surveillance system, and they capture the defendant coming on to campus at about 7 a.m. or I think about 8 a.m. Okay, it's clearly him. He's driving his gray Dodge Charger. I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They capture his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon t-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance.
They saying they got him red-handed. There's plenty footage, guys. What do y'all think?
Before the Charlie Kirk event, he's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because the pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop. Makes his way.
They did say that at a point.
On the rooftop,
hold on, let's clarify that.
The northeast.
They did say that the bullet didn't necessarily match the gun, but they said that because they were only able to recover fragments. They said, so some of the fragments may be off, but they still think it's the bullet from the same gun.
Drops off the building and runs.
Let's get us back live.
Wooded area. Police find the rifle. In the rifle is wrapped in a towel. In the rifle, they found 4 rounds, and these are 30-06 Remington rounds that one has been fired, 3 have not, consistent with the shot at Charlie Kirk. And all of these rounds are unique in that they have inscriptions on the brass. There's etchings on the brass with little political messages. Well, after the defendant turns himself in, There's a search warrant that's executed on his house. In that house, police find a Dremel tool, and they also find the same make and model of ammunition, Remington 30-06. And not only that, but one of these rounds has etching on it, consistent with the etchings on the rounds found in the rifle, right? The etching found at his house says test shot, right? So that's the second category of evidence, is the circumstantial evidence tying him to the murder weapon. The third category of evidence is confessions. The state will present evidence that he left a handwritten note at his apartment for his lover to find. In that note, he says, I had the opportunity to take out Charlie Cook and I took it, right? This note was written before he left St. George and came to Orem, and was left in his apartment. His roommate finds it, roommate/lover finds it, and this initiates a text message conversation.
That's pretty much what I said,
between
Peacemaker.
the
But
lover
shout out to
and
you
the
for
defendant,
clearing that up.
where the defendant says, yeah, I shot Charlie Kirk, and I'm summarizing, shot Charlie Kirk, I left the rifle behind, I had to leave the rifle behind, but I'm gonna pick it up and then I'm coming home. Then he also confesses to a group of friends on a messaging application. Before he turns himself in, he says, hey guys, it was me, I did it, thanks for all the good times, goodbye. And the final confession is an acquaintance is a former law enforcement officer, and he helps arrange the defendant turning himself into the sheriff's office. And when he's talking to that former law enforcement officer, he says, I got rid of the clothing I wore. Right, so there are three categories of evidence that have nothing to do, that show probable cause, have nothing to do with the DNA evidence, which is what defendant's issue is here. The fourth category of evidence is that DNA evidence. And you have to understand what that DNA evidence is. The towel that the rifle was found wrapped in was sent to the FBI lab for testing. There was also a screwdriver found on the sniper's perch that was also sent to the FBI lab for testing. The rifle itself was sent to a different lab, the ATF lab, for DNA testing. And both labs tested those materials completely independently of each other, different analysts, different labs, different locations. Both of them come back showing the defendant's DNA on those materials. Okay, the screwdriver, the towel, and the gun. I say they found the defendant's DNA on those materials. The experts and the reports that we'll present at the preliminary hearing were much more precise than that, right? Really what they say is there's astronomical odds that this DNA belongs to anyone but the defendant. But you'll see that, and I think you take my meaning here. The point is that there is substantial evidence of probable cause, far exceeding what probable cause requires. And it comes from a variety of sources. And so the defendant cannot show that the material he wants to present at the preliminary hearing would defeat probable cause. And in his reply, he says, well,
Tony, this is most definitely real. This is happening right now.
We don't have the underlying data to
This
be able
is
to
live,
attack the
Tony.
DNA evidence. Well, first of all, that attack wouldn't even affect those first three categories of evidence, right? The confession, the circumstantial evidence tying the defendant to the rifle, or the video evidence, right? But even if they were to find some expert that would say both labs independently got this wrong, and even if there's to find that kind of expert, which I think is speculation and probably against the grain, but regardless, you take that assumption, it still wouldn't defeat probable cause, because at this stage, the court doesn't weigh contrary evidence, right? The standards are very clear. At this stage, because it's such an early stage with such a limited purpose, the court views all evidence in the light most favorable to the state, right? That's State v. Virgin. So in summary, the defense has not shown that the motion to continue is based on the purpose of the hearing, a fair determination of probable cause. They just haven't shown it, and they haven't even tried. And I think one of the reasons they haven't tried is because
Hey, Ms. D, I'm putting in
they're
overtime.
experienced practitioners. They know what the standard is here. It's low. The evidence is viewed in the light most favorable to the state. They're not going to be able
Make
to
sure you
do
guys are
professional-
double tapping that
multiple
screen. That's how you hit the
professional
like button. Double tap the screen of
DNA
your mobile
evidence,
device.
right? And if the continuance was granted, it would affect the victim's right to a speedy trial. And frankly, like the Lopez case, it would obviate the repeated and express admissibility of reliable hearsay at preliminary hearings. And that leads me to the second point, which is a textual analysis. So the defense says, well, Article 1, Section 12, Rule 16 require expert discovery before the preliminary hearing. Let's try to see if my computer will present again. Let's see.
I need more coffee, Miss D.
I'm showing it's connected. Oh, there we go. Great. Okay. So let's look at the text of the rules, right? Utah Constitution, right? Here it is. Article 1, Section 12. Where the defendant is otherwise entitled to preliminary examination, the function of that examination is limited, right, to one purpose, as I said earlier, to determining probable cause. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule, in whole or in part, right? In any preliminary examination to determine probable cause, if appropriate discovery is allowed as defined by statute or rule. Is it allowed? Well, Rule 16 allows it. That's the end of the inquiry. Well, the defense says, well, no, but it has to be complied with, and that's fair, I guess. So let's look at Rule 16. So here's what Rule 16 says. Look at the mandatory disclosures, and there's a distinction here that I think is important. One is the use of the language here, prosecution team. When we talk about mandatory disclosures under A1, we're talking about what the prosecution team has, right? Prosecution team has been interpreted in the case law to mean the prosecutor as well as the law enforcement people who are working on this case. But if you go down to the timing of mandatory disclosures, it's different language that's used here, right? And I've highlighted the portion that applies here. 8, there it says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination. Okay, the different language is the prosecutor versus prosecution team. Had the Supreme Court Rules Committee, and as approved by the Supreme Court, had they wanted this to mean full discovery of everything in everyone's possession before the preliminary hearing, they would have said so, right? The rules of statutory construction say you presume all omissions are intentional, right? They use distinct language here, and they did it for a reason. The reason is because the preliminary hearing is such an early stage of the proceedings, right? We all know investigation at the preliminary hearing stage is continuing. We all know the state,
Elliot says he's innocent. What makes you so sure, Elliot? Why do you think he's innocent?
Investigative agencies have processes for getting reports and approving reports and disseminating reports. We know expert witnesses, oftentimes by the preliminary hearing, haven't even started their work, right? The Rule 7B says the preliminary hearing has to take place within 14 days where it's requested, right? This is a very early stage of the proceeding designed to protect the defendant from having to sit in custody where there's no showing of probable cause. And the rule itself, Rule 16, makes clear that discovery is ongoing. It foresees the discovery is going to be ongoing throughout the trial. So the defense argument that Rule 16 requires full discovery of this material before the preliminary hearing is a contra-textual reading. But even so, you look under A1, and what does A1 actually require as mandatory disclosures? Well, there's a specific provision that talks about scientific tests and experience. It's A1B, reports and results of any physical or mental examination, of any identification procedure, and of any scientific test or experiment. We've provided those reports, okay? What the defense wants is complete and total expert notice and expert discovery. We've even complied with A1 as it relates to what the prosecution team has with regard to the reports. Okay, so Article 1, Section 12 doesn't require discovery before the preliminary hearing. Rule 16 doesn't require full, complete discovery before the preliminary hearing. Well, is there any other provision of authority we should be looking at here? Well, how about the provision of authority that is directly on point with regard to expert notice? Let's take a look at that. 77-17-13. 1A, If the prosecution or the defense intends to call any expert to testify in a felony case at trial or at any hearing, excluding a preliminary hearing held pursuant to Rule 7, the party intending to call the expert shall give expert notice, right? It's hard for the defense to make an argument that expert notice is required before the preliminary hearing when that's not even an against the grain reading. That's a completely contrary reading to the statute directly on point. The court would have to find that this section does not apply, and it's just impossible to do that. The defense may say, well, we're not requiring expert notice. What we're asking for is just discovery here. Well, no, what they're asking for is in fact expert notice. Rule 77-1713 talks about what expert notice is. If you look at B, right, it's a CV of the expert, the report, written explanation, and then 2 says an expert's anticipated, if it's based on specialized data, the witness shall provide the opposing party the information of that specialized data upon request. Well, the expert notice request, let's see if I can find my list here. This one. To give you a list of what the defense requested in their March 25th request. And I should mention, the defense is right. This was not the first time they asked for this material, but when they asked for this material, this specialized data underlining the report, I responded by saying, look, I don't know exactly what you want. You know, you talked about like certain software files and stuff like that. Will you please put it in writing so I don't lose what you want in the translation? And so they did. So on March 25th, they gave me this supplemental discovery request, and that's what I've relayed to the agencies. But what they want is lab case files that the government intends to use in its case in chief. I should note that the FBI has provided a lot of this material already. I provided a case file that's 380 pages long. I think clear back in October, as well as about 77 other files that list their policies and procedures. And those are listed in that 225-page document that I attached in my April 3rd filing. But they list CVs of analysts, accreditation documentation of the labs, accreditation documentation of the programs used to interpret data, standard operating procedures and protocols, STR databases and frequency tables, chain of custody documentation, data files underlying the analysis, software names and software versions used, developmental validation of instruments and processes, internal validation of instruments and processes, proficiency tests of analysts, audit records. All of that material may go to expert qualification, the qualification of the labs, the methodologies, may go to 702 issues, but it doesn't go to probable cause, okay? Especially when you've got to view this evidence in the light most favorable to the state. And the final reason why we know that expert discovery, expert notice is not, I didn't finish my point here, which is this material they're requesting is expert notice. Like that's what they're requesting here is expert notice under 77-1713, which expressly does not have to be given before the preliminary hearing. And I should say, regardless of the fact that we're not required to give expert notice before the preliminary hearing, we're doing our very darndest to do so. And we shouldn't be penalized for being on the ball and getting ahead of things by trying to get the expert reports and investigation done as soon as we can. To the contrary, we should that's the kind of behavior and due diligence that should be encouraged and incentivized. And if you say, no, you can't have a preliminary hearing until all of that is done, it does create chaos in the system, because it says, if I want to have a preliminary hearing early, I'm going to stop my investigation once I hit probable cause, because then I don't have these discovery problems before the preliminary hearing. And that is not the type of conduct we want to incentivize. And the rule doesn't incentivize that conduct. And this comes to my final point. The defense knows it, okay? I know that Mr. Novak has made his argument here but the defense knows that this kind of material is not required before the preliminary hearing. And how do we know the defense knows it? Because the defense has said so. In one of their earliest pleadings in this case, docket number 16, I think it's 16, the defense counsel filed their request for discovery. This is the formal request for discovery that's filed, I think, docket 16. And in that docket, they recognize the discovery is an ongoing process. You get down to page 11, and the defense cites Rule 16 saying, prosecutor's duty to disclose material is ongoing. In every case, all material that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination, right? But here's the key phrase that I think shuts the door on this argument the defense has made, is highlighted in red there. And I quote, defendant acknowledges he does not have a right to discovery prior to preliminary hearing pursuant to Article 1, Section 12 of the Utah State Constitution. That's it. The defense concedes this point. Now, the point I'm making is what the defense makes right here in the next sentence. However, defendant relies upon this initial discovery request through trial, post-preliminary hearing, to enforce their rights encompassed in the Utah Constitution to a fair, speedy trial. That's the point I'm making, is the state should be pursuing expert investigation, their due diligence, getting the investigation done as early as possible, and providing that discovery as it comes in on a rolling basis, right? And that's what we want to have happen. We shouldn't punish the state and the victims and everyone else by delaying the proceedings when the state does exactly what has been done here, which is getting on top of those things early, right? I think that's all I have, Your Honor. Do you have any questions for me?
I will. I'm going to turn to defense for their rebuttal and then have questions for both parties. Thank you, Mr. McBride.
Thank you, Your Honor.
One piece of equipment. Thank you, Your Honor. I do want to respond directly to a number of the arguments that Mr. McBride made, but I also want to refer the court back to the accusatory pleading which initiated this case, which is the information. The information specifically relies upon two types of DNA evidence. First, the information, and it's actually the probable cause statement in the information, docket number 1. At the bottom of page 3, the probable cause statement alleges that DNA consistent with Robinson was found on the rifle's trigger. Second, the probable cause statement in support of the information says in the middle of page 6, the rifle, ammunition rounds, and towel were sent for forensic processing. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, 2 of the 3 unfired cartridges, and the towel. We have not received the discovery, and I'm not talking about expert notice, I will address that. We have not received the physical evidence and the electronic evidence that supports those assertions made by Mr. Gray when he swore to the probable cause statement attached to the information. We are not talking about the broad scope of expert notice, of expert discovery that Mr. McBride is talking about. We're talking about physical and electronic evidence, which first, the information was based upon, as I just said. And then second of all, as Mr. McBride acknowledges, the state intends to present the limited DNA evidence that it has without even having the data files been made available to us. And I want to drill down on this very specifically because I think it's appropriate, but the state sent us, but did not file with the court, a memo outlining the
Sup, Power Ranger Slayer?
sent us, but did not file exhibits that they intend to offer. A memo outlining
Sup, Power Ranger Slayer?
sent us, that it's their present plans, and it's not something that necessarily should be filed under seal, filed publicly. But as Mr. McBride acknowledges, that includes 3 DNA reports. We have those reports. We just don't have the data that the authors of the reports relied upon for those conclusions. And I'm not talking about their CVs. I'm not talking about their published writings. I'm not talking about their prior testimony. I'm not even talking about all of the things that Mr. McBride acknowledges we've asked for and that there may be a fight about later in terms of discoverability under Daubert, under 702. We're talking about a core data file. It's literally a data file, one from the ATF and one from the FBI that they generated back in September that hasn't been provided to us. So we can't provide that to our experts to help us assess whether or not there are reliability problems with the reports that the state wants to offer through 1102B4. So we're not talking about the slippery slope and months of litigation of Daubert type expert notice. Mr. McBride is right that at a certain time and place, there will be discovery litigation related to experts and then admissibility litigation related to experts. That's not what we're talking about here. We're talking about very concrete data files that our experts are waiting for. And when I say data files, I literally mean the digitization of physical evidence obtained from our client and from these objects. We didn't choose for the state to present DNA evidence at the prelim. That's their choice. And that's why we are having this dispute right now. The question that I think this court needs to also address is when Mr. McBride talks about what discovery is, quote, reasonably available to the prosecution. How can this court conclude that not having these data files is reasonable, given that the ATF and the FBI generated these data files from the swabs months ago? They've concluded their work, as far as we know. They've generated reports. The state believes that the reports are sufficiently final that they would offer them into evidence in a preliminary hearing. So I think this court should make the finding that those reports are reasonably available.
This is about Tyler Robinson, Charlie Kirk's accused assassin, guys. This is his, he's having a hearing today. This is live.
So where Mr. McBride, with all due respect to his advocacy, because he's a fantastic advocate, goes into the slippery slope of expert discovery and expert notice and Daubert, and that's really not what we're talking about here. We're also not talking about the bullet fragment further testing issue, which has previously been described as the January 9th motion, which the court unsealed. That is not a DNA issue. That is about what happens to a bullet fragment when a federal law enforcement lab wants to do what they call destructive testing. It's not to get DNA off of it. It's to look at whether that bullet fragment can be related to the other evidence in the case, because the ATF's first conclusion, as the court knows, is that they couldn't say either way, where that bullet fragment came from in terms of firearms. So that is not what we're talking about here. There is a ballistics report that the state wants to offer into evidence at the prelim, but we're talking about DNA reports.
I think
And
they're
do
talking
wanna
about
say,
the bullet
however,
now,
that
guys.
We are not suggesting that the preliminary hearing be postponed until this dispute about the destructive testing of this bullet fragment is resolved. But it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And I don't think it has anything to do with when the preliminary hearing occurs.
Mr. Novak, just to be consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date, and they actually are produced, then we've already told the court that there's a concrete amount of time that our experts need in order to analyze them. Otherwise, I've already argued about the constitutional and legal principles that are at stake here, and I think that the court has those in mind. I also want to say, finally, the Lopez case has nothing to do with this. I understand it's a Supreme Court decision, but the Lopez case is about a defendant who tried to serve a subpoena on the victim of a sex offense to have the victim testify at the defendant's prelim. That is not what this is about. We're not fighting about a subpoena. We're not talking about victim testimony. It's really not applicable. Thank you, Your Honor.
All right. Well, I'll have questions for both of you. I'll start with Mr. Novak. Again, thank you both for your presentations today in such a succinct manner. The court appreciates that. So one of the questions that's before the court, and Mr. Novak, it goes to the heart of the matter for this court as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has been presented up until this point in preparation for a preliminary hearing set for next month?
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available. If the court is saying, have you reviewed the thousands that have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, but have counsel reviewed that discovery and have we had a reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it has been provided in what I guess the state would call an abundance of caution. 30 days worth of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to. And we don't believe that we do. Have we reviewed, every FBI report interviewing people who claim to have known Mr. Robinson or known his roommate? Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No. because it's so voluminous that we haven't had that time.
Well, in really the heart of my question is, have you reviewed all the discovery that has been passed that enables you to be prepared for a prelim next month? That's that you're saying is applicable to what you understand the state will be presenting, or what you need to review. Just because the state says they're going this direction, you have to do an independent determination of the discovery on what you need to review to be prepared. And so my question is, have you done that, and are you there?
No. So for example, we received a couple months ago an external hard drive that had thousands and thousands of gigabytes, I don't even know how many, of material taken from digital devices, taken from search warrant returns from what I'll refer to as social media communication platforms, Discord and all of the others. No, I haven't had time to do that. Absolutely not. My clients, so there's a huge download of my client's cell phone. There are downloads of many digital devices. No, absolutely not.
But my question is, in order for you to be prepared, you've made the argument there's a lot, and there's no dispute that there's a lot of discovery, to say the least. But you've also said that you don't need to review it all. You just want to review what's relevant for the preliminary hearing. And so my question goes to, have you reviewed all the relevant discovery that's been passed to be prepared for a preliminary hearing that you have in your possession now?
I can only speak for myself. I'm not going to speak for other counsel, but the answer is no. The answer is no, but I am not able to, maybe this isn't the court's question, but I'm not even able to approach this fourth category of evidence that the state wants to offer at the prelim, which is the DNA evidence, because we don't have the underlying data files to be able to assess what to do about those reports. So if the court said to me, Mr. Novak, have you reviewed all the drone images that they want to use? Have you reviewed all of the video that they want to present? Have you reviewed all of the UVU surveillance? And by the way, this is a letter we received on April 4th. Have you reviewed all the Discord chats that they want to present? No. And I believe I've been diligent.
Would you like time to confer with your counsel? Because I need to know that information. I need to know that if we move forward with the preliminary hearing, either next month or a different date, that there's effective assistance of counsel moving forward. And that's one of the factors is, have you reviewed the necessary discovery? Typically in criminal cases, the defense attorneys say, hey, I haven't been able to for whatever reason. And the court recognizes that, right? Like, I get it, but I need to check that box and say, okay, defense is saying we're ready to go forward with the discovery that has been provided. That's a part I want to be sure is been accomplished. And so as you're presenting for the defense, I would ask you to confer with your counsel, because I understand that you've probably parsed out different areas for each counsel given what's there, but I need that answer as it relates to the defense team.
I now understand the import of the court's question, and I appreciate that the court has clarified that. So we can present that information verbally. We can present it shortly thereafter in writing, however the court wants to present it. But I understand that. So I'll just give the court by way of an example. I have not personally, and I don't think any of the other counsel have, but we should probably take a short break and we can discuss that, reviewed significant portions of the electronic discovery. And when I say electronic discovery, I mean images of device downloads, as well as sort of cloud-based information produced to the state pursuant to subpoenas for chats, postings, gaming communications. I mean, the primary platform is Discord with a capital D. it's a thing,
Sure.
right? So I think I'm just repeating myself, and maybe that's because obviously I would want to speak with my
Sure.
co-counsel
No,
and
I-
not speak for them.
And I respect that. I understand that you're being cautious and you don't want to present something that someone may or may not have reviewed. So I respect that, and you'll be given time to do that. But that's an important factor for the court to determine.
Totally understand. I mean, we've been trying to focus on the very specific items of discovery that we don't have, which relate directly to evidence that the state wants to present at the prelim. And the court is asking, I think, very helpfully, a broader question. And the court is not challenging, the court is not really confronting us on the question of diligence, so I'm not even going to go there. But obviously, there's been a lot of pretrial litigation on a lot of different issues. And as the court knows from our filing yesterday, there's more coming.
Right. No, and I appreciate that. And the court's intent is I just want to make sure that when we move forward, we can move forward properly and uphold the constitutional rights of Mr. Robinson and all parties to ensure that what we do is proper and appropriate, because quite honestly, I don't want to do it again. And so, I recognize, and I can do so, that both sides have been very diligent and have worked extremely hard. Obviously, I'm not in your offices. I don't know your communications, but it is evident to me that both sides have. And so the purpose of that question is that's just a checkbox I need to know to move to that stage. And only your team has that answer. And again, and I recognize the amount of discovery that's been is out there. And so it is no way to impugn defense at all, saying, well, you're not doing your job, you're not working hard. Not at all. I just want to know that answer. And so that's
I
the
appreciate
sole
that.
purpose.
And I didn't feel that the court was making those assertions. And I want to say, we hear that the court doesn't want to do it again. Mr. Robinson and his family don't want to do it again. Council don't want to do it again. We know that the state doesn't want to do it again. And we also don't want Mrs. Kirk and her family to have to go through it again, because that's actually, in my opinion, the greatest harm to surviving victims in a case like this is the long run when cases don't proceed as the Constitution requires.
And so going to that point that you just asked, so how do you propose the court balance your request for a potentially large, a long delay against the constitutional rights of victim representative Ms. Kirk in her right to a speedy disposition of the case? For example, I noted in your motion, you stated that your DNA expert needs, I believe it was 6 months.
That was her estimate.
And so how do we balance that? And I appreciate your statement, but going to your statement as it relates to Ms. Kirk's right to a speedy disposition of a party outside, right? Not counsel from either side, but it seems like we're going to be held to the timeline of somebody outside who's an expert who's saying 6 months. And that concerns the court about that is a potential hang up of, well, we can't move forward until we comport with their timeline. And that's concerning. So how do we reconcile that?
Well, first of all, if the expert needs 6 months, the data files were available in September, which was 6 months ago. And so I actually think, while I will answer the court's question, another important question is, why haven't the FBI and the ATF provided data files that they utilized 6 months ago? And Your Honor can't answer that question, and I can't answer that question, and obviously Mr. McBride can't answer that question. And so I actually think, and I don't purport to speak for the victim representative, but that's a question that the victim representative should be asking, at least through her counsel, is why haven't the federal law enforcement agencies, which took responsibility for this analysis, provided the data? Not the CVs. I mean, I've actually examined at least one of these FBI forensic examiners in another case. I have her CV. That's not my issue. We cited in our reply brief the cases which show that the victim's right to a speedy trial does not, I'm sorry to use this word in the current environment, but that's the word we use, does not trump.
You can hear the sound of my voice. Make sure you guys are double tapping that screen, guys. That's how you hit the like button.
We do
This is
not
Charlie
want
Kirk's hearing live, guys.
the victim representative,
I'm not Charlie
her
Kirk.
family.
Well, Charlie Kirk, but it's Tyler
to
Robinson, guys.
have to
Double tap that screen.
wait any longer than we have to wait. But it isn't sufficient for the state to say, we've turned over gigabytes and gigabytes and the defense, doesn't really need to review it before the prelim. That's not, obviously, and the court, I think, tends to agree with what I just said, that doesn't make a lot of sense. So we do respect the concerns of the victim representative and her family, but we can't constitutionally shortcut Mr. Robinson's right to the adequate assistance of counsel. And I think, as we said in our brief, when the state doesn't give us the data that their law enforcement partners have and have had for 6 months, we can't be constitutionally effective. And, and again, I keep talking about Mr. McBride because I appreciate his advocacy, but if the state didn't want to have to deal with Article 1, Section 12, the concept of appropriate discovery, this court's need to apply constitutional standards of reliability, Mr. Gray could have presented this case to a grand jury. And instead, what Mr. Gray did was he filed an information with probable cause that relies on multiple assertions of DNA results. We should have had that discovery under a different rule immediately. If he had reports that are based on these data files, when he filed his information and probable cause, those data files existed. Those data files must have existed on September 15th or whatever the date of the information was. And here we are past April 15th. So I will confer with my colleagues on the court's question. We will obviously answer it because it's an important question. If the court has other questions for me,
I do. And
I'm
so
prepared.
going to the state's argument that there's these 4 prongs that can be pursued in regards to the categories of evidence, and that the standard is clearly articulated in State v. Virgin, and so my question for you is, if the state's presenting evidence that can meet the standard in any of the 4 prongs, is it necessary that all the discovery for all the prongs be turned over in order for the defense to be ready to proceed at the prelim?
I'm not going to speculate about how the state's presentation at a preliminary hearing would go as to prongs 1, 2, and 3, nor could I concede that without seeing the way the witnesses testify and which reports are actually received into evidence that they establish probable cause. It's the state that wants to present DNA evidence through summary reports, not through the witnesses who wrote the reports, not through their own state lab analysts. So it's not for me to comment on categories 1, 2, and 3. I understand what Mr. McBride is representing, but I can't comment on what this court will think of that evidence. But it's the state's decision to present 3 different DNA reports, at least at the current time, according to the memo that they gave us earlier this month. And it's their federal law enforcement partners who have not complied with that reasonableness test. And that's got to be imputed to the prosecution because we don't have it. Nobody's accusing anybody seated at counsel table or over there of stalling out anything. And I think the court deserves to know why the FBI and the ATF haven't turned over these data files.
Well, I mean, I understand, but that doesn't get us to where we are today. The why doesn't help us right now.
Well, then why might tell us when. I mean, Your Honor is absolutely right. The better question is when. And then when we get them and our experts look at them, maybe there is a refined assessment about how long that takes.
So my final, oh, I'm sorry.
No,
keep
no.
going. My
That's
final
all.
question is I'm trying to avoid a slippery slope of, wait, we need one more thing. We need one more thing. We need one more thing. Are you saying, my understanding is, and I have, I understand to a small degree, given my experience about what you're requesting. You're requesting the lab notes, like all the underlying data that was put in to generate the DNA reports and the findings. Is that my understanding? What you're requesting is that is still outstanding?
What is actually outstanding is, yes, but most importantly, the data, the electronic quantification, digitization of physical evidence taken from our client and certain objects that leads these forensic examiners to conclude that there are matches. Mr. McBride says, oh, there's two different things, and so they're both right because they each independently reach the same conclusion, but they're testing different objects in different labs with different protocols. We don't even have those data. And yes, with respect to the court may be asking me a question that is better addressed by Mr. Burt, because he's the one who specifically crafted the discovery request. And I know that Mr. Burt has reviewed more of the DNA forensic discovery than I have, but I can tell the court that without those data files, we can't even start to analyze, to understand, to appreciate the conclusions, the statistical analyses, the results of those tests. So yeah, the bench notes and the protocols that were followed, yeah, that's all important, but we don't even have the data files. And there's no reason that I am aware of that has been provided why the ATF and the FBI, first of all, the ATF, why they provided it in the last 3 weeks, and why the FBI still hasn't. And so I don't think it's going to be a dribble of this and that and this and that. It should have all been produced, some of it 6 months ago, because we have DNA reports from September of 2025 that Mr. Gray relied upon for his information.
I guess what I'm trying to do is I want a bright line of saying this is exactly what we're requesting, and it's the court's decision if that's necessary.
This
or
is
needed.
exactly- Hey, Purple Group.
I just want it to be so clear that we know, okay, it is, hypothetical. We need a blue pen that is Bic or whatever. That is so definitive, there is no question, because what I'm trying to avoid is, well, okay, they provided this, but it's not exactly it. They provided this, is not exactly it. And I respect your position. I understand it. I just want to make sure there's no ambiguity. And that's why I'm trying to distill this to its finest point, so I know exactly what you're asking. Because when you say data files can be anything. I want it to be clear as day, so nobody can say, well, I didn't realize it was that. And you're saying the FBI hasn't turned over the data files. That is a very broad statement. And so I want to make sure we distill it to, it is this exactly. So the prosecution can say, okay, well, if we need to communicate with our their federal partners, then they can, and they can say, this is what we needed. But if it's just a broad, we're missing data files, that's difficult for the court to weigh whether it is actually necessary in order for the preliminary hearing to proceed.
So I think then what the court is maybe requesting or maybe suggesting is that there's going to be a continuum from what data we need in order to be constitutionally effective at this prelim versus the continuum from that all the way over to what is more in the nature of expert notice 702 Daubert issues before a trial. And as long as the state's position is none of what you're requesting, not even the digitization of the DNA taken from Mr. Robinson and the DNA lifted from these objects, if the state's position is that that's just Daubert discovery, then we can have the conversation with the court, and we can give the court our view of where the line is between what is data that should be reasonably available to us now versus what is Daubert. But Mr. McBride's position is we don't even need the digitization of the DNA swabs in order for this preliminary hearing to go forward. So if the court, I'm not trying to obviously put words in the court's mouth, but if the court's saying, I'm not going to go that far, but I need to draw a line somewhere, then we can take our discovery letter, which we gave Mr. McBride, and we can tell the court, these are the things that we think we need in order to be able to go forward in the preliminary hearing, and we acknowledge that these other things are more akin to expert notice, Daubert, and Rule 702 issues. We can do that, and it wouldn't take long, but and I think it's an appropriate way for the court to say, I'm not able to guarantee Mr. Robinson effective assistance of counsel at a preliminary hearing until the defense has these pieces, and the others can wait. So I understand the court's question, but it does require looking at a 3 or 4 page discovery letter and drawing a line somewhere, or maybe it's yes, no, yes, no, yes, no, or you know what I'm saying.
No, but to be quite blunt, that was the hope of the court for today. You're asking for the continuous because some discovery hasn't been provided, but I want to know what that is in order for the court to weigh that.
Well, we will do that today. We'll do it the moment the court wants to take a break. We can do that,
Okay.
and we can tell the court these are the things that we think that all the different authorities that I've cited require now versus the things that Mr. McBride is saying are expert discovery. And then the court will make its determination of which bucket each of those items goes in.
Sure, I appreciate that.
I think that's fantastic.
All right, thank you, Mr. Novak. I think I've asked plenty of questions. I want to afford the other side the
Always open to
opportunity
questions, Your Honor.
to have that same experience. All right. All right, turning to the state. All right, so the defense has emphasized that this is a capital case, which triggers an Eighth Amendment requirement for heightened standard of reliability at all critical stages of the proceeding. How does the state's proposal to proceed with highly technical, uncross-examinable forensic hearsay reports without defense having access to the underlying data, I use that word loosely, satisfied this heightened constitutional requirement and the defendant's Sixth Amendment right to effective assistance of counsel?
Well, my tendency is to say, well, if you require these experts to come in and testify, we're doing the same thing that happened in Lopez, that was rejected by Lopez in obviating the admissibility of reliable hearsay. And I don't think that just because it's a capital case, you throw, the baby out with the bathwater here. The rules are the rules, and they satisfy constitutional muster, and they don't change because it's a capital case. Should we pay special attention to them? Absolutely, we should, and we should keep in mind what's at stake here. But it doesn't mean there's a completely separate set of processes and rules that apply to a capital case, right? It's just that we are very rigorous in the analysis of how we apply those same rules to these facts. So I think reliable hearsay is still admissible, and that's where we are. The rules govern, and the rules clearly don't require expert discovery and expert notice before the preliminary hearing. I don't think there's any way to read the rules to require that.
All right. One of the other issues that's been brought up is defense argues that the FBI and ATF act as your law enforcement partners and therefore are part of the prosecution team. How do you reconcile your position that you only need to provide what is physically present and reasonably available to the prosecutor under Rule 16A2 with the broader definition of the prosecution team? Does the state have an affirmative obligation to compel its federal partners to produce the underlying forensic data for this hearing?
I don't think for this hearing. I think the state does have an obligation, absolutely. I think that obligation, the case law is very clear. That obligation certainly applies by trial, right? We've seen numerous cases reversed because the prosecutor has not gone out and gotten material that's in the possession of a law enforcement officer. Some of that stuff, the prosecution probably couldn't have gotten anyway because it was hidden by police officers, right? But yeah, certainly by trial, the defense is entitled to all this material. I can't say all of it because there's probably going to be some objections to some of the material they've requested, like the source code for some of the proprietary software developed in this case or used in this case. But they're entitled to most of that stuff, and we're going to provide it. And that, because that's the basis of 702 hearings and also admissibility under 702 and weight questions at trial. But at the preliminary hearing stage, no. The state does not have the same obligations, the same discovery obligations that apply at trial. Now, that doesn't mean the state can put its head in the sand either. What I think is important under Rule 16 is what is reasonably available to the prosecutor. And that's what we're doing here. The point of my April 3rd filing was to say, Judge, look at our over 20,000 documents or files that we provided to the defense. You can see in there, and we asserted at that time we provided approximately 100% of the materials that we have, right? And you can see that we're not burying our head in the sand and saying, don't give us anything else, guys. We don't want to know. No, we're saying, give us everything. And as soon as stuff comes over, we send it out. And you can see in there the dates that we receive materials and the dates that we push them out. And we're talking within a week, generally speaking, sometimes within days, no longer than probably 2 weeks. We're pushing everything out that we get. And so what is reasonably available to the prosecutor? What does the prosecutor have in his possession? Those are the materials that we've provided, and we've satisfied Rule 16. What we can't do is bury our head in the sand and say, don't give us anything else. And that has not been what's happening here. But neither do the rules require complete expert discovery and discovery of these highly technical data files. And that, your line of inquiry with Mr. Novak just a minute ago raises the importance of this. Yes, the defense, I can't tell you the first date that we had a conversation, an oral conversation where they said, hey, we need the data files. And I remember a conversation we had, I can't remember, Mr. Bird, if it was with you or Mr. Novak, and I said, well, look, assume I'm an idiot. I don't understand what data files are. Tell me exactly what you need. And they say, well, we need the software files that can be used in the software program so our experts can run it. Okay, put that in writing so I understand and don't misrepresent what you want. And so when did they put it in writing? March 25th. So once I got it in writing, that's when we started looking through. I looked through my file and analyzed, do we have this stuff? Have we provided it? Help me understand what's going on. And after I did my analysis, I sent it off to the labs and said, hey, I've done my analysis of what I think we've provided here. Will you guys look at this and see what you think you've provided? And then tell me if if you haven't, get it to me. If you're not going to, tell me why. And we had that communication. We had a communication about that this week with both ATF and FBI. And I think a lot of this material they've requested, we have provided it. Some of this material was provided clear back in October, most of it. A 380-page digital case file from the FBI, disclosed October 24th, debate stamp 79, CVs of 3 of the analysts from the FBI. There's case notes were provided October 24th, that's Bates 122, and Bates 845 to 848. 73 files of policies and protocols, validation, testing procedures, analysis, proficiency procedures, provided October 24th and on December 9th. Now, the ATF lab, they were continuing to do investigations, not investigations, but expert scientific work on this case until the end of February. They chose to wait until they finished to compile all of their case files and to get them to us. We're talking thousands of documents. You don't snap your fingers and have them all together. It takes time to put them together. Once they got them together, they sent them to the SBI for processing, make sure that the detectives, investigators are aware of the materials, and they provide them to us. We bait stamp them and send them out. And those are the materials we received this week. Okay, so there's been no delay here. And we've done what's required under the rule. But I think the important point is to go back to the purpose of the preliminary hearing, because what you're talking about here is have we completed full expert notice? I mean, I know Mr. Novak says, well, that's not what we request. Well, that's what we understand, and that's what the pleadings seem to request. And this material, these data files, those are materials covered under full expert notice under 77, 17, 13, not under Rule 16, and certainly not under, there's no mention of when this material has to be provided elsewhere. So I just don't see that how this is necessary for the limited purpose of the preliminary hearing, particularly in light of all the other three categories of evidence here. I think this is why Mr. Novak couldn't talk about whether or not this discovery material of expert material would affect the probable cause determination. This is why the Lopez analysis is so important, is because you can hear the evidence, you can listen to it, and you can say, you know, there's the confessions, there's the circumstantial evidence, there's the video evidence, and then there's the DNA evidence. I don't even need to consider the DNA evidence. And there's probable cause here. And that's the state's position, is that there's probable cause regardless. And there's no showing the defense can make that would say it's going to undermine probable cause here. That whatever their experts say, best case scenario for the defense is they get an expert that says both labs messed up. It doesn't affect probable cause because you weigh the evidence in the light most favorable to the state with relation to the DNA evidence. And there's all this other evidence anyway, a confession. That's clearly probable cause. So I would ask the court to hold off.
We need 8 more likes, guys. If you haven't hit that like button, double tap that screen, man. We're watching Tyler Robinson live in court over the live of Charlie Kirk, guys. Double tap that screen if you don't mind.
Talking about here because that's exactly what I asked for, and they gave it to me on March 24th, less than a month ago. So that's the process I think you should follow. And, you know, I know the other thing the defense has said is, well, look, the state doesn't have to use this evidence. They're right. We don't have to use the evidence, but we're not going to not use it where the rules allow it. We're not going to back down because of an argument that's meritless in our view. We're entitled to use it. We're going to use it. If the court decides not to rely on it, that's fine. You know, so that's my position on that.
Final question, and I appreciate both sides in their presentations. Is there a reason that you recognize that the defense would be entitled to a continuance?
Well, I think there's two components to that in my mind. First is, you know, in a lot of cases, we will stipulate to a continuance, you know, out of professionalism, preparation. You know, there's a lot of things that we stipulate the continuances on, but generally we're talking a 2-week, you know, maybe a month continuance. Here, this is a significant continuance that we think violates the victim's right to a speedy trial and affects our ability to get justice in the case. But the second component is why, yes, we would absolutely stipulate to a continuance under some circumstances. This case, it's hard to say because there's these 4 different categories of evidence that I've told you about. And the failure of any one doesn't mean the rest fail, right? Each one of these categories of evidence really establishes probable cause on their own. So it's hard to say why we would agree to a continuance in this case. You know, I mean, I'm thinking of a recent case I had where defense counsel's father died right before trial. I stipulated the continuance, okay? Something like that happens, of course, we're gonna extend that professional courtesy to the defense. You know, as it relates to preparation, I don't think the defense needs to, and this kind of goes to your question to defense counsel, hey, are you gonna render effective assistance? And I'm thinking, you know, if I were in your shoes and they say they need more time to be prepared, yeah, that's a legitimate concern. And would I agree to a continuance for them to be prepared under certain conditions? Absolutely. You know, for example, let's say they hadn't reviewed the 35 exhibits we're going to present, right? We've narrowed it down, you know, given greater notice than is required by the expert notice statute. In fact, you know, more than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses we're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided, maybe I've got it on a list here, but I know you have it in that letter I sent.
Sub Levy.
The last one was provided there's a tool marks report that was provided March 12th. Okay, so under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits. They're the DNA reports. There's photos of the rifle found, photos of the rounds in the rifle, surveillance video of the defendant on the scene, video of the shooting itself from people in the crowd, those type medical examiner's report, doorbell camera video of the defendant approaching in his car. The defense has all this. They can be prepared on time. So yes, there are circumstances, but I don't see them in this case.
Thank you.
Your Honor, may I?
Thank you for the
may I
gifts,
go back
Lovey.
to The request that the court made for a little more clarity. Exhibit F to our motion is Mr. Burt's discovery letter, which Mr. McBride and I have both been speaking about. And Mr. Burt is prepared right now to tell the court which pieces of the discovery letter we view as core discovery that we're entitled to before the state offers any DNA evidence at the prelim, and which pieces of that discovery letter are more in the nature of expert notice under Daubert. So if the court wants to hear from Mr. Burt right now, we don't have to delay that, but I want the court to understand that Exhibit F is probably the template for that.
And I'm happy to hear from Mr. Burt. Is more time needed, Mr. Novak, to confer on to my first question about the discovery that's been reviewed?
Yes, I think that would have to happen during a short break.
Would a 15-minute break help accomplish that?
Very much so. I'm sure others would appreciate it.
All right. Well, let's turn to Mr. Burt, and then the court will take a 15-minute break, recess. Mr. Burt.
So, Judge, to simplify a pretty complicated issue, this DNA testing, it's a black box technology. That technician processes a sample, puts it into a genetic analyzer, and what he gets is electropherogram, these little squiggly lines. I'm sure the court's familiar with that. But the machine that they put the sample into generates internal electronic files. And when the FBI or the ATF analyzes the samples, they can adjust the parameters to decide how low of a level do they want to look at the sample. And they have set standards. If it falls below a certain level, they don't want to look at it. That's just the way they do it. And in this case, what you have on all the samples, they're what are called complex mixtures, up to 5 people in each of the samples. So when they have that kind of a situation, then they use another software program called STR Mix. And they run this program, which also has internal files. And that program supposedly sorts out whether various people can be identified with a sample. So of the information we requested initially, way back on September 16th, we requested all electronic files. And in dealing with the FBI and the ATF for many years, when you make a discovery for electronic files, they know, Mr. McBride might not know, but the FBI and the ATF knows that what you're talking about when you're asking for electronic files is the machine output that can be used by another expert to reconfigure where the DNA readings are taking place. And they can only do that when they have the underlying electronic data from the genetic analyzer. So the FBI was given our initial discovery request, and I don't know, I've done probably 100 cases with either the FBI or the ATF. And when you ask for electronic discovery, you get 2 things. You get the case file, and that contains all the underlying notes of the analyst who is processing the scene. You get the electropherograms, which are the little squiggly things. And you typically get a disk with the electronic files on them. Those files cannot be read by lawyers. It requires software that lawyers typically can't afford, $10,000, $20,000 for the software packages, but they can be analyzed by the experts. And that's the information that we're asking for here. And so it's not correct that we didn't ask for this stuff in the beginning. We did. We did have a subsequent discussion where Mr. McBride said, I'm unclear on what electronic files mean. And so I did provide in a letter specifying exactly by file extension names exactly what that meant. And in the discovery letter we sent to him, to answer the court's question of what's essential here, item number 6, data files, please provide copies of all computer data files created in the course of performing the testing. And then it specifies both raw data and processed data. These files should include all sample files, FSA and or HID files, matrix files, standard files. Any DNA expert would look at that and know exactly what we're asking for. And again, it's standard. It's all it is, pressing a button. They can put that on a disk and give it to you within the day. But for some reason, it wasn't provided. And so that's item 6. That's essential information. And the second essential piece of information in this discovery letter is item 9, the STR mixed data. And under that category, we've listed 6 elements of the electronic data related to the XTR mix. The rest of the discovery requests are broader in scope. And as you were told, that's going to be worked out. But the 2 key elements that we don't have are 6 and 8, or 6 and 9 in this discovery letter. If we had that information, we could get it to the experts. The experts could look at it, see how complicated it is, give you better estimates how long it would take to put together their analysis. And their analysis, we have to depend on them because we don't have the expertise or the software to be able to read these data files.
So, and I appreciate that clarity. That's exactly what I was looking for. My next question is, let's hypothetically assume, and the court is not trying to indicate any direction.
Sure.
But let's hypothetically assume I say that's not necessary to move forward at the prelim. Is your expert ready to testify?
Ready to testify at the prelim?
Yes.
The expert would be prepared to come in and explain to the court what they could opine based on the information they have. But the bottom line of the opinions would be what they stated in their declarations to the court. Without the underlying data, it's impossible to draw conclusions. Part of it, the issue here, the specific issue is the STR mixed data that we're asking for includes the internal validation records. The internal validation records tells the lab how many people in a mixture they can reliably assess using the software. And we cited some cases to the court in the continuance motion where courts around the country are struggling with this issue. There's a certain number, if you surpass, that you can't reliably sort out a mixture. So the experts would come in and tell the court that, but they'd also say, till I see the internal validation files, the underlying data files, I wouldn't be able to tell the court whether they can reliably sort out these mixtures or not, because I haven't looked at what their files say.
So, and I appreciate that, but my question is, have you received the lab notes? I understand, it sounds like in order to simplify it, there's some internal settings for these machines, calibrations and such.
Right.
That is separate than lab notes. Where
Right.
Now, I just want to make sure I'm on understanding. Have you received the lab notes for the DNA that the state is intending to move forward on as they've given you notice? Have you received that data?
We've received the case file, the lab notes, I'll call them, from the FBI, not the ATF. So we're missing the ATF lab notes. We do have the FBI lab notes, but those lab notes will tell you how the sample was processed up to the point when it was put into the machine. It will not tell you anything about whether the machine reliably spit out the number of contributors in the sample or how they sorted out, how they're matching one of the 5 or 6 people in each sample to Mr. Robinson. That's where we're lacking the information. So I have reviewed the lab note files that tells me how they process the sample. But the critical issue here is, can they reliably sort this out given the complex mixture that they're dealing with. And so that question cannot be answered based on the information that we have and we reviewed.
Thank you, Mr. Root. I appreciate that.
Thank you.
It provides a lot of clarity. All right, let's go ahead and we're at the 12 o'clock hour. Let's break for 15 minutes, come back at 12:15 to confer with defense in regards to discovery. And then we're going to transition to talking about the media in the courtroom. As indicated, it's not the court's intent to issue a ruling about continuing the preliminary hearing. I want to weigh the evidence, the oral argument, the information today, but I am also cognizant of the timelines. And so that ruling will not be delayed because both parties require that, as they should. With that, court is now in recess.
All right, so they taking a break. We not. You know what I'm saying? We most definitely not. Okay, so let's move on to the next point of interest, guys, which involves Tom Holman. You know, two ICE agents have been charged in Minnesota, guys. You know, this ICE thing has been going on for a minute now. Yeah, man, Minnesota is most definitely fighting back, guys, as they have charged two ICE agents with crimes in Minnesota. Check this out.
Immigration officer, let's listen. Was reached earlier in this case than in the shooting of Julio Sosa Solis and the killings of Alex Preddy and Renee Good. I know the community is following the decisions of this office very closely, and I want to be transparent on why these situations are developing at different speeds. This case followed the typical investigation and submission process for cases coming to our office. The Minnesota State Patrol received a 911 call from the victims, who had a gun pointed at them by the driver of a vehicle who pulled up next to them illegally on the shoulder. The State Patrol was able to investigate thoroughly, identify Mr. Morgan, and conduct an interview with him at the Whipple building. After finalizing the investigative case file, the State Patrol submitted the case to our office for potential charges. Virtually none of the obstacles around evidence collection that exist for the January shootings exist in this case. On February 5th, Mr. Morgan was driving illegally on the shoulder of eastbound Highway 62, or the Crosstown, just past the Portland Avenue exit, appearing to attempt to bypass slower traffic. The victim who was driving briefly moved their vehicle into the shoulder to slow him down. Mr. Morgan was driving a rented SUV with no markings or other features to indicate that it was an ICE vehicle. After the victim's vehicle moved back into the legal lane, Mr. Morgan sped up to pull alongside the victim's vehicle. Mr. Morgan then visibly slowed his vehicle to match the pace of the victim's vehicle, opened his window, and pointed his duty weapon directly at both victims in the other vehicle while continuing to drive illegally on the shoulder. Both the driver and the passenger in the victim's vehicle felt threatened by Mr. Morgan's actions. The driver called 911 while the passenger began to video the SUV when it pulled into the lane in front of them. On February 6th, State Patrol investigators conducted a voluntary interview with Mr. Morgan and his partner, who had been in the back seat of the rented SUV at the time of the incident. During the interview, Mr. Morgan admitted that he was driving the rented SUV, and he and his partner were headed to the Whipple building to end their shift. Additionally, he admitted that he drew his firearm after the victim's vehicle had already rejoined the normal flow of traffic, corroborating details from interviews with the victim. The State Patrol retrieved video of the incident from highway cameras, which is also consistent with the details of the interviews. We have charged Mr. Morgan with 2 counts of second-degree assault, 1 count for each victim for threatening the victims with a dangerous weapon. Second-degree assault with a gun has a presumptive sentence of 36 months in prison. Mr. Morgan's conduct was extremely dangerous. Driving while pointing a weapon out of your moving vehicle at the victims who were in another moving vehicle could have led to yet another disastrous incident in a community that has already suffered too many. I want to thank the Minnesota State Patrol for their investigative work on this case and for submitting it to our office for charging consideration. Today's charges reflect an important milestone in our efforts to seek accountability for the harms inflicted on our community during Operation Metro Surge. Our community is still navigating the effects of the federal occupation. I drew daily inspiration from the courage of Minnesotans and the care that they showed for each other during Metro Surge. Our work continues on all fronts, from the killings of Ms. Good and Mr. Preddy, to the shooting of Mr. Sosa Solis, to the incidents being investigated by our Transparency and Accountability Project, or TAP. We will not rest until we get the answers we seek about federal agent conduct across Hennepin County and accountability is delivered wherever appropriate. Thank you. Questions?
Yeah, Mary, do you know where he lives and will the state, presumably if not Minnesota, will they cooperate with extradition? Or what are the next steps here?
So the question is, do we know where Mr. Morgan lives? We do not. We would certainly hope that he would reach out to us and voluntarily turn himself in, but we will wait to see.
It looks like the complaint says he has a Maryland address. If he still lives there and if he's still employed by ICE.
The question is.
So they will be pressing these charges against the ICE officers, guys, for assault.
The complaint says he had a Maryland address. Do we know if he still lives there and whether he's still employed by ICE? We do not.
Are there any concerns about federal blowback? The administration hasn't made, they've said that they won't be pleased if there are charges against any federal officers involved in deliberation activities.
The question is, are we concerned as to whether there would be federal blowback? They've indicated they would not be happy, something of that nature, if federal agents were to charge, not a concern of ours. Our role, by the way, is to hold people accountable if they violate the laws of the state of Minnesota. And in this particular case, we feel strongly that this agent committed second-degree assault against both of these victims. We have charged the case, and our intent is to hold them accountable.
On that note,
yes.
Yes, Mary, on that note, the Trump administration has said these agents have absolutely a message to them and a message to community members who, because of that, probably feel this is a waste of time.
So the question is, the Trump administration has said that agents have absolute immunity. That is wrong. They are wrong. And I think they've actually walked that back. We know that the vice president insisted that federal agents have absolute immunity. That is not true. They do not have absolute immunity. What could happen is that a federal agent who is charged could ask a federal court to remove the case from state court to federal court. Our office will still be prosecuting it, whether it's state court or federal court. As part of that, we would expect a federal agent to assert a supremacy clause defense, but that requires, and the burden is on the agent to show that what they were doing was within the scope of their authority as a federal agent. Our opinion is that illegally driving on a shoulder, pulling up to a car and pointing a gun at the heads of two community members who are not doing anything at the time is well beyond the scope of their authority as federal agents. So they may say that, but we will litigate that in court. And there is no such thing as absolute immunity for federal agents who violate the law in the state of Minnesota or any other state.
Why did it take about 2 months to file these charges?
So we got the case, actually I can't remember when we got it. It's because it came in during our normal processes. What usually happens is law enforcement investigates a case, they submit it to us. I don't recall when it got submitted to us. Do you remember? Yeah, okay. It was submitted to us in February on an out of custody basis. Because our office has thousands of cases, we prioritize in custody cases. And we also took our time in making sure that we understood what all of the facts were here and making sure that we were thoughtful in charging the case.
Is it fair to say that there was any delay associated with making sure you got it right, given the national eyeballs on this being?
Rob, why you think she lying, Rob?
Who might have pulled a gun in a road rage incident?
Well, I would hope that our team, and I believe this to be true, would take the time we need in any case, especially an out of custody case, if this incident had happened to any other member of the public. But certainly we were trying to figure out and trying to get additional details so that we could make sure that if there is a motion to remove, if there is a claim of federal supremacy, that we are prepared to respond to that.
Can you clarify if you know he is in fact still an ICE agent?
I do not. We do not know that.
What if he refuses?
Well, they trying to stop him in Minnesota, CT. They trying to stop him in Minnesota.
There is now a warrant for his arrest. That warrant is nationwide. And so he could be driving and get pulled over by an officer for a speeding ticket or something like that. It is not a pleasant thing to have a warrant out for your arrest. It impacts many different things that people try to do. So that's our hope, that he'll want to get this resolved. If he doesn't, it is also our expectation that law enforcement, if they encounter him, or frankly, ICE should make arrangements for him to turn himself in. But that warrant will remain out there until we get him in custody.
Has there been any contact between your office and Mr. Morgan's attorney, or DHS?
Has there been any
communication?
Yeah. Has there been any communication between our office, DHS, or Mr. Morgan? No, there has not. As I said, the State Patrol took a statement from Mr. Morgan that was recorded. So we don't need anything in addition right now.
Is this the
any indication that the victims in this case were involved in observing ICE agents, legal observers?
Any indication that the victims in this case were involved in any activity in observing ICE agents? No, there is not. In fact, as we make clear in the complaint, this ICE agent was driving a black SUV that had absolutely no markings or any indication that would give anyone an indication that they were ICE agents. So no. In fact, I think they were on their way to go shopping.
Is this the first federal officer charged in connection with Operation Metro search?
Yes, this is the first federal agent charged in connection with what happened here in Operation Metro Search.
Why do you think they cooperated now, ICE cooperated and made him available for an interview with state police, whereas they would not with any of these other cases?
Why do I think they cooperated now? I might have speculation on that, but I don't want to be speculating right now. We'll just rely on the facts and see what comes out during litigation.
So is this also the first case of its kind nationally?
Is it the first case of its kind nationally? We believe it is. We believe it is.
He didn't specify, can you put a point on that? What was the name of the first that's
Max.
national?
Well, so there have been federal agents who have been charged in the past on DWIs and things that were very clearly unrelated to their what they were doing on behalf of their jobs, right? The federal agents in this case say that they were returning from their shift to Whipple. If there are federal, if they claim that they were on duty, we will litigate that in federal court. So that's what makes it different.
Were the victims, in the charges it says the victims temporarily anyway pulled over onto the shoulder. Was that real?
So the complaint says the victims temporarily pulled over onto the shoulder. I think that is something that you will see people do occasionally when somebody is behaving in an illegal way by driving on the shoulder, which was clearly illegal, and speeding up behind them. And I think you've probably all seen situations where people will pull over a little bit to kind of give them the message that what they're doing is illegal. This is the crosstown, and so it narrows to one lane, and so the traffic slows down because it's one lane, and so traffic was backed up, and the vehicle, which was unmarked, unbeknownst to anyone that it was ICE, was kind of speeding up on the shoulder, which was illegal, it appears, trying to bypass the traffic. So, is that a good thing to do? Probably not. But the victim had pulled back over into the legal lane and was there when the vehicle of Mr. Morgan pulled up next to him and drew a gun and pointed it at their heads. That, we believe, was illegal.
Right, you made that clear.
Wow. They ain't playing in Minnesota, guys. They are not playing. 2 ICE officers have been charged with assault, guys, in
The
Minnesota.
question was about whether the 2 victims.
They say they are not bigger than the program.
Are you worried about that in your defense, and is that an illegal act?
So the question is, with the victims moving over, the driver moving over, are we worried about that in our defense? No. And this is why. While they did that, Mr. Morgan's vehicle slowed down and then sped up to get parallel right next to the victim's car, rolled the window down more, and pulled out his duty gun and pointed it at their heads. That was not legal and had no legal basis, no self-defense, no nothing. There's no legal defense there that would allow them, even if they thought the driver was trying to cut them off, the driver had already pulled in to the legal lane. It was after that Mr. Morgan's vehicle pulled up next to it, slowed down to pace the car. And remember, he was driving. Mr. Morgan was driving illegally on the shoulder, rolled down the window, and pointed a gun at these 2 people. That is illegal.
I don't think there's any question that that's a more serious offense. It's obviously very serious and dangerous. Again,
That was Hennepin County Attorney Meredith Moriarty announcing charges against an IH agent who allegedly pointed a gun at a driver and passenger after the driver tried to block him from illegally driving on the shoulder. Moriarty says Agent Gregory Morgan was driving on the shoulder of a highway in an unmarked car, apparently trying to bypass traffic, when the other...
All right, so let's go here to where they have more on this story, guys. Hold on. You know what I'm saying? You get the full context of what exactly happened. They got this guy charged. Hold on. We're going to let Tom Holdman talk in a second. Let's go here.
We have seen the first state charges now against an ICE agent involved in that federal immigration crackdown in Minnesota earlier this year. A prosecutor there is accusing this agent of pointing a gun right at 2 people inside a car while he drove alongside them on the shoulder in an unmarked SUV. He is now charged with 2 counts of second-degree assault with a dangerous weapon. There's a warrant out for his arrest. He was part of Operation Metro Surge. You remember that? That's when the president deployed 3,000 federal agents to Minnesota. 2 people, Renee Good and Alex Preddy, were shot and killed by immigration officials during that period. The Department of Homeland Security did not immediately return our request for comment. Let's bring in Ryan Riley, who's joining us now. Can you help us understand this a little bit? Who's bringing the charges, what we're learning here, and whether this is just the beginning?
Yeah, so this is the county attorney who announced these charges, which makes it this sort of really interesting and unique scenario where you have a county prosecutor bringing charges against federal agents. And the question now becomes, what response will the Trump administration have to that? Are they going to stand by the officer? Are they going to try to move this to federal court? Just a lot of questions raised by this, but here's some of what the prosecutor had to say.
Mr. Morgan then visibly slowed his vehicle to match the pace of the victim's vehicle, opened his window and pointed his duty weapon directly at both victims in the other vehicle while continuing to drive illegally on the shoulder. Both the driver and the passenger in the victim's vehicle felt threatened by Mr. Morgan's actions.
And she, called that behavior extremely dangerous. But this is obviously, I think, one of those cases that's going to be really closely watched. And I think that response from the Justice Department, from the Trump administration regarding what handles here, or whether they defend the officer is going to be something to really watch closely.
Okay, Ryan Riley, keep an eye on that one for us. Thank you very much for the update.
We thank you.
There was a little bit more on that situation where they saying that the ICE official basically pulled up and pulled a weapon, on somebody for no reason. Got himself some charges. All right, let's hear from Tom Homan, how he feels about all of this that is going on. He says they are basically trying to handcuff ICE agents, guys. You know what I'm saying? Basically trying to stop them from doing what they need to do for national security. Check it out.
Today, many of the services or the service providers that we use have not been paid. In plain terms, that means aircraft,
it's going to be
patrol
Tom
boats,
Homan
patrol
in his own
vehicles that need
words.
service, they're being parked. Border surveillance equipment that requires maintenance is offline until funding is appropriated. Our confidential human sources are not being paid, and we're at risk of losing some of our intelligence tools that help us secure the border.
Border Patrol and ICE officials testifying today in Congress at a House budget hearing as their teams continue to go without funding. The partial government shutdown now in day 61. Let's bring in Trump administration border czar Tom Homan for more on this. And I'm wondering, Tom, where is the urgency in getting funding for DHS? Congress was on a 2-week break over Easter. We didn't hear boo about this. They come back and they're still futzing around trying to get it done.
Well, they're getting paid, so they're not in a hurry. Look, I was up on Hill numerous times meeting with members of Congress, talking about what ICE does, what ICE doesn't do, what Border Patrol does and doesn't do, which is even more important. And they're trying to change the law through the appropriations process. They want to legislate things that prevent ICE from doing things. They don't want to reform ICE. They say reform ICE. They want to handcuff ICE like they were the last 4 years under Joe Biden. Things like, well, we want body cameras. Well, we already addressed the body cameras. We're implementing nationwide. Matter of fact, the funding you're holding up is going to give us $120 million to buy more body cameras. They want to talk about sense of location.
$120 million ought to give everybody a body cam. Goodness gracious.
Can't arrest illegal aliens with sense of locations. And I responded, well, give me one instance where you arrested an alien inside of a hospital, inside of a church, or inside of elementary school. What's the problem? You can't point to one instance that happened. The only one that violated the sanctity of a church was John Lemon and his group. So, they want to change the law through appropriation, what's never been done before. If they don't like what ICE is doing, then legislate new laws and put it in federal statute, and that's what we'll do.
Tom, Sandra here, what is your warning as far as the consequences if DHS is not funded?
We're in a situation right now with what's going on in the world. We're in a heightened threat posture right now. All hands should be on deck. And Rodney Scott, CBP commissioner, we just showed him testifying. He's exactly right. A lot of what we do is done by contractors, right? We're cops. We have contractors that put surveillance balloons in the air and have this modern technology of wiretaps and T3s and all the sophisticated equipment that the big, beautiful bill bought and that we had prior to that. We have a lot of contractors keep those things moving. For instance, my security, I'm my own security detail, their credit cards are maxed out, right? Because the travel cards aren't being paid because of shutdown. And there's agents across the country and 20,000 men and women in ICE. They travel a lot doing these criminal investigations, and credit cards are being maxed out. So it's really putting a dent in how we're enforcing law, especially during the time of a heightened threat posture because of what's going on in the world. National security is extremely important right now. It should be a nonpartisan issue to fund the Department of Homeland Security. I don't get it.
Yeah, the acting ICE director, Todd Lyons, was at that hearing earlier today, talking more about who is and who isn't getting funded. Listen to what he said.
Our critical intelligence network is a lot contract based, and we're just not able to pay for those contracts right now. Our victim advocates, victim specialists, we just don't have that. So while we always hear that ICE is flush with money, maybe for detention and removal, but not for the critical things that are actually protecting Americans every day. And one of the most vital things we do is child exploitation.
And I think a lot of people don't have the full perspective on this. Yes, there is money for ICE and CBP up until the end of 2028, but that's for enforcement and removal operations. There's a whole other set of layers to CBP and ICE that aren't being funded.
Exactly. A lot of our work is done by really smart people and contracted companies that do sophisticated stuff like targeting, right?
Mm-hmm.
We have partners that use, I gotta be careful what I say, it's law enforcement sensitive, but they look at various databases
Mm-hmm.
and help us find people that don't want to be found through modern technology but that's been hamstringed because of funding. So the men and women carrying a badge and gun, they're being paid. But the people that make it possible for us to do what we do, even the mission support staff who make sure that the vehicles, the fleet's being maintained, we're getting gas in the vehicles, power's being turned on to these buildings, travel vouchers are being paid.
Yeah, that was in that Lorenzo, the 30K, the 50K that was in that brown paper bag.
But if they didn't do what they did, we couldn't do what we do.
I want to play out sound from Mark Wayne Mullen on all of this. He joined Laura on the Ingram Angle last night.
Okay, so right now we have an issue going on with Republicans because they're having to vote for a bill that essentially funds 20 components out of 22 that I have. And the two that are separate are CPP and ICE. And they're having a problem because they say we feel like we're defunding it, but we're not. What we're doing is we're having to do it through reconciliation so Democrats can't use it for political gains and try to shut down the government again September 30th.
Tom, how do you weigh in on that?
I agree. But look, let's do it through reconciliation. I'm sick and tired of sitting at a table, telling them, what ICE does and what we don't do. More importantly, because they think we out there separating families, we're raiding churches, and they want all these changes. They want masks off. You know what? We'll consider taking masks off when you stop going on national TV and calling ICE racists and Nazis and secret police, which raises a threat level to over 8,000%. So you know what? Let's do it through reconciliation, because I will not sit at a table and give up any authorities that ICE and CBP has to protect this nation. If you don't like, I'll say it again, if they don't like what ICE is doing, then legislate. Do your jobs and change the law. Until then, we're going to do what the President Trump was elected to do, secure the border and make this country safe again by removing criminal aliens that are in the country illegally.
Yeah, and let's not forget, too, that the funding for DHS runs well beyond ICE and CBP to the non-military people who work for the Coast Guard, Center for Cyber Security and Infrastructure, all of that. I mean, how many departments are there in DHS? Like 25 or 40, something like that. Tom, always good to talk to you. Thanks so much for being with us.
Thanks, Tom.
Right.
All right. So right as they finish with Tom Homan, guys, we get more from Tyler Robinson. He's live in court right now. Let me get him up here for y'all. Look.
Issue that we want to address that will assist when presentation of the evidence from both sides for the next portion, and I want to make sure that's seamless. All right, Ms. Visser.
Thank you, Your Honor. Our intention is for each attorney to briefly discuss where they are at as far as rendering effective assistance of counsel at the anticipated preliminary hearing dates. I just want to note a few things. For my part, I have been doing my very best to keep up with all of the discovery productions. I certainly have not read everything. But I think it's important to note that we are just starting to find what we're missing. Although the state has indicated there are 35 exhibits for the preliminary hearing, as this court is well aware, we'll have law enforcement witnesses that also testify to hearsay from other law enforcement witnesses, which means we need to read all the law enforcement reports, right? We need to review all of the interviews that are likely to come up in that testimony. So we are in the process of determining what reports we're still missing, and there are some still missing, and what interviews we are still missing. And we are still missing interviews. And we haven't sent an updated list to the state as of today because we don't want to piecemeal it. We don't want to just ask for one thing at a time because we know it's a process to go to the law enforcement partners, get it to SBI, SBI get it to the state. But we are creating a list. And The discovery in this case, the only way I can really describe it is that it is like a living, breathing organism, right? Every time something comes in, we have to check our list, see if it's something that we've been waiting for, something that we've anticipated or requested. So if the court is asking me personally if I feel like I'm ready to render effective assistance of counsel in May at a preliminary hearing, the answer is no. Both because
They not
there's
ready,
not enough
guys.
time
The defense is saying they not ready.
everything that we are missing and get that requested and review it in sufficient time to render effective assistance of counsel, and just the sheer magnitude of what we're dealing with. We're dealing with dozens of law enforcement agencies, hundreds of reports. We are going through it as quickly as possible. But of course, the most important thing to us is rendering effective assistance of counsel. So if the court is asking my opinion of me right now, the answer is no.
So, Ms. Pfister, I appreciate that. When will you be ready? With
So
what you have right now?
with what we have right now, so this is one of those things where you're ready when you have to be ready, right? Based off of my calendar and what I believe I need personally, well, we need the DNA. So
Well, let's focus
outside of
only
the DNA,
on what you have, what's before you now.
I would say I need at least 4 months to finish processing what I have based off of my calendar, my trial calendar.
All right. Thank you.
Thank you.
Good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. I don't know if you recall, it's been a long time, but when we were first setting this prelim, I mentioned to the court that for the months of February and March, I would not be available. I was involved in a murder trial in Summit County. And so for the entire months of February and March, I was not able to work on this case. The trial ended, I think, March 17th or 18th. Then I got sick for like 10 days. So I have not been able to turn back to Mr. Robinson's case until the beginning of this month. In the time that I was in trial, we've had 7 disclosures from the state. Many of those disclosures involve thousands and thousands of pages. One of the biggest disclosures we got was on March 5th while I was in trial, and it consisted of the entire FBI file, which was massive. That's what I've been focusing on the last 2 weeks, reading it as fast as my eyes can read it, because a lot of the reports I think that are going to come out through the SBI originated through interviews with the FBI. So I've been trying to get my head around that file. And that's just one portion of one of the 7 disclosures. And there were thousands of pages. And I think I've made it through the FBI file now, but I haven't even touched any of the rest of it. And as lead counsel, I do expect to have at least a portion of the witnesses at the prelim. I share Ms. Visser's concern about, even though there's only 35 exhibits they're going to introduce, that doesn't limit the testimony that's coming in. And I feel like if I'm going to do a job, a good job, that I need to be able to be familiar with everything that officer has touched, and really what the SBI has done generally. We went to examine physical evidence this past week, this week. It took us 6 hours. We did finish what the SBI has. However, we still have never seen the gun. The gun is at Quantico. So we've never been able to look at the gun. I actually think that's really important for purposes of the hearing. So I have some concerns about that. I also have not been able to get into my client's phone. The electronics that we have required an expert because they're so massive. We had to all get these huge hard drives shipped to us from our digital expert. I have not looked at my client's phone, and that concerns me, especially because the state's indicated they may call individuals uniquely connected to my client. I'm not going to say who because I don't want to commit you guys if you call them or not. But we've been given the names of some witnesses they may call, and what is on my client's phone I think is going to be really important. So I would share Ms. Visser's request for 4 months. I will tell you, I handle quite a few murder cases in the state. I think my last murder case that we had a prelim, we continued it, I think 3 times, and there was 2 terabytes. This case has over 200 terabytes. So I think in the scheme of preliminary hearings and timing, this is not unusual or out of the ordinary for a homicide case in the state, especially one this complex. So personally asking for a little more time, setting the DNA completely aside. Even if the court, even if they get up and say, forget it, we're not going to introduce the DNA, even if you say, I'm not going to listen to the DNA, the rest of it is still significant. I also have some concerns that we do have a notice of intent to seek death with an aggravator. So I assume we're going to go forward with that at the prelim. No one's discussed that. If that happens, that does require really careful review of the scene itself, which I don't know that we're there yet, but we're close. I mean, we definitely have looked at so many videos. I think I've memorized the face of everybody in the crowd. But if we're going to go forward and the court has to make a decision, if you're binding over on whether or not it's capital, whether or not there's an aggravator, that's a whole nother section we have to get into. So for all the same reasons, I would ask for 4 months at least. Thank you, Your Honor.
Thank you, Ms. Nestor. Mr. Burt.
Yes. I've had 2 primary assignments in the case. One is dealing with the media litigation, which has taken substantial amounts of my time. And I'm responsible for putting the hearing on today and working with the experts. And so a lot of my time has been devoted to those kinds of preparation issues. In addition, I've been assigned the task of dealing with all forensic issues at the preliminary hearing. And those efforts so far have involved me sorting the discovery as it comes in, because it's not come in discrete packages. Discovery dump 1 might have some DNA discovery in it, and the next time we get something on DNA is in discovery package number 4. So part of my process has been going through everything as it comes in to sort of sort and get organized the various areas of discovery. And so far we have information coming in on the following areas: autopsy experts, canine deployment, crime scene photographs, DNA, fingerprints, firearms, footwear, laboratory intelligence unit discovery, question documents, state forensics, and trace evidence. So I have set up files for each of those areas. I'm uploading and organizing and reviewing discovery as it comes in each of those areas. We are retaining experts at the point in time when we feel we have enough information so that we're not paying experts to have to duplicate or do discovery review in batches. We're taking on the burden of getting it organized so that we're not spending a lot of expert resources on reviewing discovery. So we have retained the DNA experts, and we're stuck on that issue. As you've already heard, we've retained a firearm expert who is awaiting the case files from the ATF. We just got in the second to the last discovery batch the autopsy photographs that were produced in September. I think we got those just in March of this year. So those are being reviewed and organized so that we can hire a forensic pathologist who will review the autopsy report and prepare us to do whatever cross-examination we need to do on that report. But we have not yet retained that expert. So that's kind of an overview, and happy to answer any questions. I don't feel, given the state of discovery and the complexity of some of these forensic areas, that I'm in a position to render effective assistance. The DNA expert estimated 6 months. I think if we got the minimal 2 categories of information that I outlined for the court, that we could expedite that down to approximately 4 months so that they'd be prepared in that time period.
Thank you, Mr. Burt.
Thank you.
Mr. Novak.
I've already been told I used too much of the court's time, but I think I can supplement.
No, I appreciate all the efforts of every party, and I know it's important, and so that time is necessary and needed. So I appreciate hearing from you.
I'm not going to represent that I'm responsible for all of the motions and pleadings that have been filed, but I've really devoted my time to writing. And obviously the court has held many substantive hearings on issues so far. Obviously everything that we write is a collaboration, but I think that the vast majority of the time that I've devoted to this case has been the legal writing and frankly coordinating the mitigation investigation, which I'm not going to talk about beyond saying I speak almost daily with the people involved in our mitigation investigation, reviewing mitigation materials. That's where I'm focused. And obviously that's not part of the prelim. So if we were shifting to fulsome preparation for the preliminary hearing over, say, the next 30 days, I would have to basically put aside all of the writing that needs to be done and direction of the mitigation investigation and figure out where with my colleagues they need me to fill in so that we are all constitutionally effective when it comes to the preliminary hearing.
And so if, as it relates to what you are maybe assigned to as it relates to the preliminary hearing, how much time would you need?
I think the estimate of my colleagues of 4 months is appropriate. And I also think that what we are all saying is whatever time our DNA experts need once they see the data that Mr. Burt so eloquently explained, to your honor, we don't have, that's really going to be the controlling time period. We're not, in other words, we're not going to say, oh, our DNA experts are ready, but counsel are not, because I think that 6-month estimate by our expert, which was provided in a declaration, is going to be the outer limit, but that's going to be from when they actually get the data. And as Mr. Burt said, there may be a refinement of that once they see the data that's available to them. I mean, that was sort of a best assessment based on past experience, not based on what the data in this case presents in terms of the challenges for analysis.
Thank you, Mr. Novak.
Thank you.
All right, as and anything, just turning to the state, any benefit of the record that's needed?
I would just add, I haven't seen everything in the file either. That doesn't stop me from being prepared. This is a massive file. Probably, I don't know, 70–80% of the file is running down leads that did not lead to any fruitful evidence. And so a lot of what this is categorizing evidence. And the core evidence that's required at the preliminary hearing has been provided for a long time with the intent that I could help the defense. And this is exactly what I said in my letter that I wrote to them with the witness and exhibit list. I provided very explicitly the witnesses we would call, the Bates numbers of the reports that talked about the witnesses that we would call, including the Bates numbers of the reports of the witnesses we would use 1102 statements for. I included all of the exhibits, the Bates numbers for those exhibits, the dates on which those exhibits were provided for the defense. I see no reason why the defense can't review that material. We could probably review it in an hour or two with them, and they could sit down, look at those exhibits, look at those reports, and be prepared for the preliminary hearing, Your Honor.
Thank you. All right, thank you to all parties. I appreciate that guidance. I've made note of it. As indicated before, we will take another brief recess. We just need to get technology set up to ensure that it's seamless as you're making your presentations. And we'll come back at the 1 o'clock hour. Council also uses time to prepare. So when we start at 1, we're ready to jump in. We'll start with defense, and that way we can be efficient with our time. Thank you. Court is now in recess.
All right, so now they done gave us another break. You know what I'm saying? About a 15-minute break again. Okay, so y'all know that ICE is under fire, guys, right? So they had the agents had to go. Well, the head leaders of ICE basically had to go testify in front of Congress, guys. Yeah, Congress most definitely on their top as well, man. ICE just can't catch a break, man. They can't catch a break until Tyler Robinson's case come back. We're going to check out what exactly happened during this deposition, guys.
And so we're going to do one round of questioning for the panel in an attempt to get through this meaningfully. And so I know you guys are thinking, oh, great, man. I hope they ask the other two guys all the questions. Because we're compressed and because the committee's work product is due when it's due, I want to say this. We are going to, the standard stuff where if anybody has any additional questions, please let the agencies know. We will let the minority know what questions we've sent in, and we would ask that you give us some indication of what's out there so we can track the tickle file. I know everybody's fully employed, but we're going to ask for your responses in 48 hours from when they're received. And you're like, holy mackerel, we got plenty to do. If you can't get it done in 48 hours, then we want a response in 48 hours saying, we can't get it done, and here's why, and here's when we'll have it to you. Time and date certain. Not my first pick on how to operate, but I've got the situation that I've got. And if it's like, if somebody's like, it disappears and it's crickets, then we're going to be aggressively following up saying, what the heck? We need the answer to that. I also would note that there was a request that went out, Mr. Lyons, it was for a contract at the Montana facility, and it came out from the committee staff, and I believe it was Mrs. Escobar that did it. We don't have anything. And so if you guys think there's some reason why it shouldn't be given to us, I want to know that in writing by the end of the day. And if there isn't, then we want to copy the contract in 48 hours so it can be evaluated for whatever purposes are appropriate. I'm unaware of anything that makes that classified or anything like that. So please and thank you in advance. We're in order. I've already done my cry thing about the compressed schedule. And I think everybody here is well aware of what's going on with DHS and the different talking points and all that. So I won't bore you with that. I'm just going to turn to my distinguished ranking member, Mr. Cuellar, for his opening comments.
Mr. Chairman, thank you so much for holding this hearing, and welcome to the three witnesses that we have here. Well, I'm happy that we kick off the FY 2027 hearing season for the department. Doing so under circumstances of a government shutdown is something that we need to recognize. I recognize the department has been shut down for over 2 months now while utilizing funds from the reconciliation to support pay for personnel. Our work on FY 26 still remains unfinished. I know there's a lot of ideas on how best to fund the department for the remainder of this year and next, but I would be remiss that if I did not express my opposition to the approach that abandons the funding for the department annually. The work we do on this committee is critical to national security, but no two fiscal years are alike, and challenges that the agencies face are always evolving, limiting our ability to respond and demonstrate oversight over federal funding for the department on an annual basis. Not only abandons our Article 1 obligations, but it will be irresponsible to the taxpayer. The collective budget for these three agencies before us this morning make over almost half of the department's discretionary funding. Their underlying missions are at the heart of immigration policy, a debate that Congress has wrestled for over several decades. These policies that impact lives, our economy, and our community at large, they're important, what we do up here in Washington. As a member from a border state, and actually I live just about a mile away from the border, we know that these three agencies play a very important role in my backyard.
Make sure you guys hit that like button if you have not. Double tap that screen,
in everyday
guys.
lives. The border is not just a place that I visit, but it is a home. The men and women of CBP, ICE, USCIS are my neighbors. And as a ranking member, I recognize the toughest parts of this bill rest in finding an agreement on how best to address the funding and adjacent policy changes across CBP, ICE, and USCIS. Earlier this year, when 2 American citizens were killed during the federal immigration enforcement operations in Minnesota, it brought many questions to the forefront for the American people. Not only how this happened, but what comes next? What comes next? And at that time, I demanded an independent investigation to be done into this event, but it remains unclear what, if any, progress has been made on this front. I don't think it's possible for us to recognize that these events are the reason why FY 2026 DHS bill remains unfinished. Again, absent a final bill for FY 2026, we also must recognize the funding windfall for CBP, ICE, USCIS received during the reconciliation through both direct funding and fee adjustments. I suspect we will have many questions about how this funding, specifically the $75 billion appropriated for ICE, how that's been executed. I also think it's important that we recognize who did not benefit from reconciliation, such as the men and women Homeland Security Investigation, HSI, within ICE. The role that they play in criminal investigations and fighting drug trafficking, human child pornographers, and all that is critical to our national security. Moving on, when we talk about border, we must focus on immigration and security. There's no doubt that it's important, but we often forget about how important the border is to our economy and our livelihoods. Trying to find the balance between security, trade, and tourism is important, especially to our border communities. So I look forward to talking about some of these issues that we're seeing at the ports of entry, checkpoints that we're seeing. And finally, USCIS, I hope we're able to discuss the utility of this new law enforcement arm that involves hiring, training, maintaining 200 new law enforcement, something that USCIS has never done before, and how this would not be duplicative of the work that ICE is doing already. There is a lot of things that we need to cover today. I want to thank the witnesses for being here. Look forward to, I think I've talked to most of y'all, and look forward to spending a little bit of time after this committee. So with that, I want to say to all the 3 witnesses, thank you, Mr. Chairman. Thank you so much for holding this meeting.
Thank you to the gentleman from Texas. The gentlelady from Connecticut is recognized for her opening statement.
Thank you very much, Mr. Chairman and Ranking Member Cuellar. And I want to welcome our witnesses this morning and thank you for being here. I want to begin by noting the absurdity of holding a hearing on funding for these agencies when Republican leadership has openly decided to pursue a partisan funding process outside of the Appropriations Committee. Slush funding the government through a series of partisan budget bills that are written in back rooms by Republican leadership driven only by political interest is a recipe for catastrophe.
Will the gentlelady suspend?
I will.
We're going to mood music somewhere. Okay, the floor is yours again.
Thank you. Thank you. We're going to repeat that. Slush funding the government through a series of bipartisan budget bills that are written in back rooms by Republican leadership driven only by political interest is a recipe for catastrophe. My colleagues across the aisle have loudly hailed the work that we were able to accomplish in passing 11 of the 12 appropriations bills. They are right to do so. It is important, and yes, it is difficult work of governing. That's what governing is about. But the very fact that it is difficult ensures that it will endure. Abandoning the appropriations process in favor of partisan reconciliation bills will come back to haunt this institution. If we go down this road, there is a cliff at the end, and I strongly encourage my colleagues not to do this. The most direct reason that the entire Department of Homeland Security is still shut down after more than 60 days is because Republican leadership refused to pass the bill that the United States Senate unanimously passed twice. They agreed to this. We have the Congress, both House and Senate, you get unanimous consent. We can't get unanimous consent to say that the sky is blue, but you had twice vote in the Senate on unanimous consent basis. And they have passed it twice. It is now still being blocked. They're blocking this bill because they will not allow any funding for the Department of Homeland Security to move forward unless it also includes funding for ICE and CBP, without any new protections against the misconduct that the American people are demanding. They are demanding these protections. These agencies are in dire need of serious reform to build back public trust that has been lost. We all have seen the footage of the brutal and senseless killings of Renee Nicole Good and Alex Preddy. We have seen our cities terrorized, communities afraid and terrorized by ICE and CBP. 44 detainees have died in ICE custody since President Trump took office, including 25 in this fiscal year alone. That is 20-year high for an agency that was only formed in 2003. In January of this year, ICE violated nearly 100 federal court orders, which the chief federal judge in the state of Minnesota estimated was more violations than some federal agencies have committed during their entire existence. Law enforcement in Minnesota is investigating 2 ICE officers for kidnapping, false imprisonment after they kicked in the door of an American citizen without a warrant, forced him outside at gunpoint, threw him in the back of their car, and then drove him around until they realized they had nothing to charge him with. ICE officers in Minnesota tear gassed a family on their way home from a basketball game, which caused their 6-month-old daughter's heart to stop beating before she was rushed to the hospital. A detention officer in an ICE facility recently pleaded guilty to sexually abusing a detainee over the course of several months in 2025. There was an ongoing investigation into 2 immigration officers for potentially lying under oath after they shot a Venezuelan man in the leg. A Cuban man died by homicide due to excessive force at an ICE-run facility in El Paso. I could go on, but I trust I've made my point. It is abundantly clear that significant reforms are needed. I have been very clear on my own position. We need border security. I do not favor abolishing ICE, but significant reforms are needed. This is the United States of America. Officers should be required to get a warrant from a judge before they kick in someone's door. Agents should not be able to hide their faces and conceal their identities from the public to evade accountability for misconduct. American citizens should not be detained and deported. And when there are cases of misconduct, there should be mandatory independent investigations. I understand that reforming these agencies will be the product of lengthy negotiations. I understand that negotiating is hard work. I understand that it can be tempting to just give up, to try to go it alone. But I promise you, that is not a sustainable or responsible way to govern. I encourage Republican leadership, stop blocking the bill that passed the Senate unanimously twice so we can fund the vast majority of the Department of Homeland Security, FEMA, TSA, Coast Guard, cybersecurity, Secret Service, and while we continue to negotiate with regard to ICE. I encourage my Republican colleagues to join us in the difficult work of forging agreements rather than abandoning the process in favor of a strictly bipartisan path. I thank the chair and ranking member, and I yield back.
Without objection, the witness's full written testimony will be entered into the record. With that in mind, we would ask you to please summarize your opening statements in 5 minutes. Mr. Scott, the floor is yours.
Chairman Amade, Ranking Member Cuellar, members of the committee, thank you very much for the opportunity to appear here before you today to discuss the President's fiscal year 2027 budget for U.S. Customs and Border Protection. As America's unified border agency, CBP is responsible for knowing and controlling everything and everyone that crosses our international borders. CBP serves Americans every day by keeping bad things and bad people out of our homeland, and for protecting our international supply chains to empower our economy. I'm incredibly proud to represent more than 68,000 dedicated men and women of CBP who continue to perform this vital mission every day, even though they can't count on even being paid right now. It's bewildering to me that we are here today discussing a budget for 2027 when Congress has yet to enact a budget for 2026. 7 months into the fiscal year, CBP has been shut down more than we've been open. One obvious impact of this funding lapse is the thousands of personnel that have gone without pay for extended periods of time. And until Congress acts, I can't even promise them when they're going to get their next paycheck. But the damage goes beyond the missing wages, and it cannot be fixed by merely doing a back pay restoration. Today, many of the services or the service providers that we use have not been paid. In plain terms, that means aircraft, patrol boats, patrol vehicles that need service, they're being parked. Border surveillance equipment that requires maintenance is offline until funding is appropriated. Our confidential human sources are not being paid, and we're at risk of losing some of our intelligence tools that help us secure the border. As World Cup approaches, CBP is unable to provide our personnel the advanced training that we had planned for this event. The negative impacts are not limited to border security. Many of our contractors are small family-run businesses, and now they face the prospect of laying off their employees or going out of business because we can't pay them as we had promised. The problems will compound until this body takes action and funds DHS. I've talked about some of the bad stuff, our current challenges. Let me talk about some of the amazing things that we've done over the last year. Because of President Trump's leadership and the support from Congress through the Working Families Tax Cut Act and the commitment of our personnel, CBP has fundamentally transformed the border, and we have shut down or we have stopped the open borders of the past. As a result, illegal entries between the ports of entry are at record lows, and we have reclaimed control of our border. Investments in our personnel.
All right, let me stop this, man. That was ICE. Hold on. We got Tyler Robinson back in the courtroom, guys.
Second of all, we've put on a hard drive that we're marking as Exhibit B all of the PowerPoints that are going to be displayed for the court, all of the scientific studies that are going to be cited by Dr. Ruva, as well as the underlying videos that are going to be displayed. Some of the videos are, because of the time limitations, have had to be edited. So we get to the gist of what we want to show to the court. But the entire video clips are on the hard drive if the court wants to look at it. I've also provided a document of all the transcripts of all the electronic media coverage from September 10th through today. It's about 6,000 pages.
I see.
But just in case the court wants to look at any of the material, the actual full context of some of the clips we're going to show the court, it's there. And in terms of what else, so I move that into evidence as well.
So that would be Defense Exhibit B?
Correct.
All right. And
no objection for the purposes of this hearing. And I would just say, Judge, that while these are being received into evidence, the state has no objection for the purposes of this hearing. If we move to another sort of challenge with respect to venue, for example,
I see.
We may have to revisit any sort of stipulation.
Thank you, Mr. Grunander. And just for the benefit of both parties, I meant to start with this. So we have a monitor set up here for a court reporter. I just want to make counsel aware that it could be picked up on the camera, the transmission. So if there's something that should not, please make the court aware and we can adjust accordingly. But I just want to make aware so our court reporter can look and accurately make note of what's happening in court. So just FYI.
Thank you. And Your Honor, just in terms of what's in front of the court in Exhibit A, tab number 1 is the CV for Dr. Edelman. He will be our first witness, a social psychologist and the person who conducted a survey of the community opinion. He's going to talk about that. the survey he conducted is tab number 2. Tab number 3 is his PowerPoint, which is very lengthy, and there's no way we're going to be able to get through it in the time allotted, so I'm going to do the best I can to summarize it for the court. Tab 4 is Dr. Ruva's declaration, and Dr. Ruva's, Christina Ruva, R-U-V-A's CV. She will be our second, and we're only going to have 2 witnesses. We're originally going to have 3. We've condensed it down to 2.
Okay.
So you have her CV on tab 4. Tab 5 is the report she submitted in support of the motion that we filed back in December. Tab 6 is a supplemental report that she wrote after the state and the media filed their opposition to the motion. Tab 7 is her PowerPoint, again, very lengthy, and because of its length, we're not going to be able to present the entire thing to the court. 8 is a document that is currently under seal. It's a declaration of Amber Robinson, and the court has sealed that. So one of the issues is whether it should remain sealed. And it relates to the issue of the privacy.
If you have not, take time to double tap that screen. That's how you hit the like button, guys. This is Tyler Robinson in court live.
Privacy concerns of witnesses and others. So that is currently private. 9 is the declaration of Matthew Robinson, also private. 10 is a declaration of Ms. Nestor regarding some threats she has received, and that's we're not offering that as private. That's something that the court can consider. 11 is a declaration from a prosecution witness whose name is Samuel New, N-E-W, indicating his objection to being televised and the reasons for it. 12 is a declaration of another prosecution witness, James Rawlinson, indicating the same thing. And Your Honor, just to let the court know, there are over 3,000 witnesses, so we have not been able to survey any of them except the 2 that we're providing to the court in terms of whether they have privacy concerns. When we get to the argument, I'll be addressing that issue, but I wanted to alert the court that we do have witnesses who are, at least these 2, who so far have stated their opinions.
Thank you, Mr. Burke.
So I'm prepared to call Dr. Edelman at this point.
All right, and just before we do, this may not be applicable, but just to be thorough, is either party invoking the exclusionary rule?
Your Honor, we've discussed that, and I think with the agreement with the court that we would not invoke the rule, and the prosecution's expert or witness will be allowed to attend, as well as Dr. Ruva would still listen to Dr. Edelman. I think that would expedite the process.
Thank you.
That's accurate, Judge. Generally, there is an exclusion for expert witnesses. In part, that's the reason for the stipulation. The state's witness is going to be a fact witness, but nonetheless, the defense is not objecting to him being present.
All right, thank you for addressing that. That does streamline things. All right, Mr. Burt, call your
Dr.
witness.
Edelman.
What's up, Grace? As the judge makes his decision, guys.
Your Honor, there was one other issue I wanted to raise with the court. When the court made its ruling on the 13th, opening this hearing to the public, I believe, if I'm not mistaken, that the court reserved the issue of whether particular parts of the hearing would need to be closed. And there are certain slides, video presentations, that when we get to those, I will be asking the court to take them in camera explaining why I think so, and we just, for the record, ask the court for a ruling.
Thank you. I appreciate that heads up.
Sure.
Doctor, if you wouldn't mind coming forward, standing right here to be sworn in.
So we have an expert witness, which is a doctor, guys, coming in to basically speak to us now. This is Charlie Kirk live, guys.
Stand right here to be sworn in, and then we'll have you come to the stand.
Not Tyler
You
Robinson.
do solemnly swear that the
Charlie
testimony
Kirk.
you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Now you can sit up there.
All right, so if you'd like to get seated, make yourself comfortable. Looks like you brought your own water bottle, but generally we have water bottles. So go ahead and get situated and then bring that microphone close to you.
Sure.
Just want to make sure that the audio record picks you up. So
Okay.
go do that. I appreciate it.
I feel so tiny in this chair.
All right. All right, Mr. Bird.
Thank you.
What's up,
Tell
Chris?
us your name and tell the court what you do for a living.
Sure. My name is Brian Edelman, and I am a trial consultant based out of California.
And what is your educational background?
I have a PhD in social psychology and then an LLM in international law.
What does a trial consultant do?
So as a trial consultant, I work more with attorneys and counties and other clients, more of as an advocate, I would say. And I do pretrial research such as focus groups, mock trials. I help with jury selection, so write juror questionnaires, oral voir dire questions, attend jury selections, give recommendations in terms of cause challenges, peremptory challenges, a lot of post-trial interviews after trials are over, so post-verdict interviews. And I also work as an expert, which is different hat. So when I'm doing this type of work, it's more as an objective person, so I'm not advocating for one side or the other. So that's a different role.
What were you asked to do in this case?
Can you speak in I'm sorry.
Sure. What were you asked to do in this case?
So at this point, what I was asked to do was to assess whether or not people in the community are being exposed to media coverage, how closely they're following it, and what their sources are. So not a change of venue survey. A lot of the work I do isn't change of venue. I would not classify this as a change of venue study.
Okay. There's a binder there in front of you. Would you take a look at tab 1, please?
Sure.
Is that your resume?
It is.
And does it set forth all the cases you've worked on, either change of venue or doing community surveys, the kind that you were asked to do in this case?
Yeah, for the most part. I mean, I'm probably not all of them are in here, but yeah, these are most of them.
All right. Now, did you prepare a PowerPoint
I
for
did.
this case? And is that in tab 3 there in front of you in the binder?
Yes.
And I've informed you we have some time restrictions here, right?
Yes.
Do you think you're going to be able to get through this whole?
I'm going to talk really fast. I've had a lot of coffee, so I think it will be good.
Okay, good. So if I could bring that up.
All right.
Okay. So why don't you walk us through what you were asked to, or what you're going to present here in your presentation?
So I'm not going to talk about the social science literature just because Dr. Rube is going to do that. But primarily we'll focus on the extent and nature of the coverage in this case. And this isn't a change of venue study, so it's really focusing on what coverage has come out of these hearings, more of from the video streaming and video cameras in the courtroom. So not looking at an analysis of the prejudicial nature of the coverage per se, like we would in a change of venue survey. And then the second part is the survey that was done to see what impact this has had on the jury pool. Are people following it? What are they seeing? And what impressions they have at this point. So I would consider this like the baseline. This is the floor of where we're at right now. And we'll see what happens moving forward. And then the last section, if we have time, talks about some of the challenges cases like this pose when you're trying to pick a jury in a community like this.
Right. So you said on the first area, the social science literature, that's something Dr. Rubis is going to talk about, but did you have one key point you wanted to make there?
The only thing I want to say about it, because we'll touch on it when we get into the media coverage, is, there's a lot of research on this, and the main takeaway I want to talk about is the types of pretrial publicity that are most prejudicial is emotional pretrial publicity and pretrial publicity around the character of the defendant. So all I'm going to say is because it'll come up later.
Okay, so I'm going to skip ahead.
Okay.
To the extent of the coverage, and has the coverage impacted the jury pool?
Right. Okay. So again, this is just looking at two things. Where are we at today in terms of the extent and nature of some of the coverage, focusing on the question of whether or not having cameras in the courtroom is potentially prejudicial, and if it's creating sensational content, or is it more of a neutral nature that, people watching live streams and things like that? And then what impact has this coverage had so far on the jury?
And question 2 is answered by your survey?
By telephone survey, yes.
All right. So let's take a look at the first area, the media coverage.
Okay, so I just wanted to touch on the extent of the coverage. So the data here come from two different sources. The first source is called Newsbank, and that's an archive of newspaper coverage. So when it's looking at the coverage in the state of Utah, there's 831 articles in that Newsbank that are sources that are based in the state. And it's probably a conservative number because it's not exhaustive. There's things that are missed, but I'd rather be conservative than overly inclusive.
Right.
And then Utah County, 697. And I believe it looked at like 15 sources primarily, 15 newspapers. It also includes Fox KSTU, the local Fox station, and there's 209 news segments that are in that archive. The last section there, that row, is from a Lexis search, which is different, and it captures transcripts. So there's 441 of those that are nationwide, but it is limited. So it doesn't include Fox News. It doesn't include, I think, MSNBC, NBC. So it's not an exhaustive list. It's only certain.
I'm sorry, to include.
If you can hear the sound of my voice, double tap that screen if you have not. That's how you hit the like button. It helps out the channel, guys. Double tap that screen.
And I told the court that on his thumb drive, or on his drive that we provided, was the 441 transcripts, 6,000 pages.
Yeah, that's right.
You've seen that?
I have seen that.
Okay. Next, I think you're going to look at the nature of the media coverage, and what was the framework you used to do that?
Yeah, so one thing I wanted to touch on is this is the American Bar Association rule, so 3.6 about pretrial publicity. It's not the rule, whatever the Utah one. This is just the ABA. And the thing that stood out to me initially is when we talk about people who work in, attorneys, people involved in the case, like what they should and shouldn't introduce to the public. And one of those things that are key factors to me are extrajudicial statements that the lawyer knows or reasonably should know, will be disseminated by means of public communications and have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. So anything that's particularly prejudicial in nature, you shouldn't be releasing if you know it's going to lead to bias. Examples when we talk about the defendant, I mentioned defendant character evidence is particularly prejudicial. We have character, credibility, reputation, or criminal record. And then tests and things like confessions, admissions, statements given by a defendant. When we talk about tests, it could be DNA, ballistics, things like that. And then opinions as to the guilt or innocence of the defendant. And then anything they know might be admissible. So this is the stuff I look at. Are things crossing that line? Because those things are particularly prejudicial. And I think the ABA, a lot of that is driven by the research that tells us that.
Okay. We're on slide 14. What does this show us?
So the reason I point this out is because a lot of the prejudicial content that's come out so far that you see in the media and keeps being reproduced on social media, in television newscasts, is what was initially released in this press conference. So, it was the indictment or arrest affidavit, and there's a lot of prejudicial details that are distributed in there where it's, a very long press conference. We're literally reading text messages from the defendant to his roommate, and they're prejudicial. They imply there's some degree of guilt in there, and it's reading it, the whole thing, which is then disseminated and it gets reproduced on TV and reproduced again and again and again. It appears in social media posts, reels on YouTube, and a host of other places.
And does that reproduction include when the coverage relates to in-court appearances?
It does. So, we'll get to that, but the information that was here keeps getting reproduced in a sensational way on TV. And not only that, like he's reading it. When you see
some people say
graphic,
innocent though. Why you think he's guilty?
Implies this is the actual text message on a phone that came from the defendant, and it's not. So it's very prejudicial and misleading.
So you say on your slide, this serves as sort of a megaphone and a distributor of certain information.
Yes, and
is within the categories you set out.
Yes, and when it's being distributed, just to point out, it's not like it's only distributed on conservative media outlets like Fox. It's on CNN, NBC, all of the networks. So it's widely being distributed to all types of viewers.
And in terms of other sources of this megaphone effect, your next, and by the way, you've got the actual video of the press conference.
Yeah, this is a clip of it.
We're not going to play that
yeah,
because of time limitations, but it's
right
there if the court wants to look at it. Are there other sort of megaphone factors here?
Yeah, so this is a unique factor in this case, in the sense that people who are very influential, obviously the president of the United States, or former attorney general, these are people that have a lot of influence and power, perceived credibility, and they're making strong prejudicial inflammatory statements. And I think that's unique. I don't usually see that in cases, and calling for the public execution of the defendant before there's been a trial, things like that are unique in nature.
All right, Your Honor, this is one of the slides I would like the court to see, and it's, as he just indicated, expressing opinions, strong opinions about whether Mr. Robinson should be executed. So the court wants to take it in public, that's fine, but for the record, I'm asking the court not to do that. I do think it's important that the court hear this, just the tone of it and the substance, I think, is very important for the court to consider. Since we are submitting it, the PowerPoint is on the drive. The court could listen to it outside of the public domain, however the court wants to proceed.
So I'll make note of that, and I'm happy to review that in its
Thank
entirety.
You. If we're not going to play, just one thing that's unique about it, if we're not playing it, is
sure.
There's inflammatory language in there that also creates in-group, out-group identification. When I think,
could you explain that?
Yeah, so it's like a lot of people identify with a political side. Unfortunately, I'm a member of the Democratic Party or Republican Party. I'm liberal. I'm conservative. So I think there's some language in that clip where it mentions, I don't remember the exact phrase, but something about like lunatic leftists or something like that are doing this. So it creates this. The out-group is dangerous. They're lunatics, maniacs, or whatever phrase was used, which creates more of danger, the perception that members of that group, that out-group, are dangerous, and there's a danger there. So that's something that comes up later as well.
And how is that kind of information more or less prejudicial?
Well, it groups, again, in-group, out-group identification, and we think members of the out-group are not like us. They tend to, they're all the same. We have to attribute stereotypes that of how those people behave. They're more likely to impact how we see them. You're less likely to have empathy for members of the out-group when group salience is high, versus members of our group we see as individuals or complex, less likely to be impacted by stereotypes, more likely to empathize with them, identify with them, things like that.
Okay. Now, did you actually take a look at the court appearances that have so far taken place in this case to see what was discussed, so that you could compare what was happening in court with what the electronic media was reporting was happening?
In terms of the comparison of what's happening and what's being produced?
Yes.
Yeah, I did look at that.
So the timeline, could you explain this, what you have up here?
So this is just a timeline of the hearings that have taken place and like high level what they were. So like the initial WebEx appearance, pretty brief, and you would think that's a pretty neutral, not very significant hearing, and you would expect if you're looking at the media, it should be neutral. It shouldn't be highly prejudicial, inflammatory, since very little happened there, right? Mm-hmm. And the same thing when you have like the waiver hearing, appointment of counsel, There's not a lot of fireworks. It's not the preliminary hearing. No evidence is being laid out or anything like that. So you would expect the media not to be introducing prejudicial content, given the nature of those particular hearings.
If they were serving an educational function.
If they were educational, transparent, a summary of what occurred, these are very procedural, technical things. They're not necessarily sensational in any way.
So did you take a look at the first hearing, the initial WebEx appearance by Mr. Robinson?
Right. So this is a brief, short hearing. I think he appeared on WebEx, right? And then I looked primarily at what did that elicit? What was the reaction to the media? Was it kind of just summarizing this is what happened, or was it more sensational in nature?
Okay, so let's take a look at the clip. And this is from NBC
You have been
News
watching that court
on that
hearing
date,
for
correct?
the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson, there not speak.
I think we got a problem with the audio.
To thank all parties for being here, and this concludes to thank all parties for being here.
Well, I need to. Let me check and see. That's in settings.
Is this source? Yeah, the volume for the source might allow for amplified volume.
Oh, yeah, right. Okay. That's what I.
Good question. Who is paying the lawyers? I don't know, Nancy. Great question.
Speaker. It's not coming up by the laptop. Okay, we'll do that. Okay. Okay, so is this first slide from it's not in that? All right, let's try that out.
There we go.
There we go. Okay, let me escape. Slide. Okay.
Did you skip the previous?
Yeah, let me go back.
19. There you go.
There we go. So is this, as you indicate on the slide here, this is ABC's coverage of the September 16th, 2025 WebEx appearance?
Yes.
And in this clip, are you picking up the coverage right after the court says we're in recess?
Yes.
Okay.
A lot of people feel just like you, Vanessa, that this man may be innocent. He may be being framed. Is there anybody else out there that feels like Tyler may have been set up? You know what I'm saying? It's also a lot of people that say it's a lot of evidence against Tyler, and saying that he's most definitely the one that done it. But hey, opinions vary. Shout out to everybody with their own opinion. Make sure you double tapping that screen if you have not. You know, we're watching live coverage of Tyler Robinson in court. He's alleged to be the one who took out Charlie Kirk, guys. Make sure you double tapping that screen if you can hear the sound of my voice. This is how you hit the like button. It most definitely helps out the channel. Shout out to everybody out there. Right now, we waiting on this doctor that they have on the stand to start talking, guys. He's talked a little bit. They're trying to find something so they can ask him some questions, and it's just taking a little second. Man, we should be over 200 likes by now, guys. If you haven't hit that like button, double tap that screen if you don't mind. It helps out the channel, man. We need 19 more likes to hit 200, guys. If you're in the building and haven't hit that like button, double tap the screen of your mobile device or click the three dots in the right-hand corner and hit that thumbs up, guys.
I'm sorry. Okay. Apologies to the court. Thought we had this set up. Let's do. I've rebooted. Say again. Pull that HDMI cable out now. Plug it back in. That work?
There we go.
There we go. Okay. Yes. I think we're good. Okay. My apologies. So you're picking this up from the point in time right after.
Tell them to hurry up.
Showing the whole hearing.
Yes.
And this is kind of the aftermath.
Right.
You have been watching that court hearing for the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there, not speaking, wearing what appeared to be some kind of green vest, as the judge read out the 7 charges against him, including, of course, aggravated murder. The state making clear that they are seeking the death penalty and putting in place, the judge did, a protective order, apparently at the request of the state, for Erica Kirk. Charlie Kirk's widow. I want to bring in Danny Savalos.
Erica Kirk got a protective order, guys. Remember, they said it's been threats to her life.
On that protective order that the court finds the defendant represents a credible threat to the physical safety of that person here being Erica Kirk. Danny, stand by for a second. I want to go back to Steve Patterson here. And Steve, it has been a remarkable series of developments over the course of the last several hours as state officials, the Utah attorney there earlier in the day described, and the charging documents.
I think Erica Kirk and Trump are supposed to be meeting up today, doing a press conference.
22-year-old as their suspect.
I think at like 4 o'clock Central Standard Time.
And in doing so, we got the TikTok, we got the charges, also these, the exchange of text messages between Robinson and his roommate. These are details that we simply didn't have before. One thing that sort of gels with what we saw in the text messages, this exchange again before and after between Robinson and roommate, who believed to be romantic.
We are 6 likes away from 200. Double tap that screen, guys. 6 more people hit the like button. It helps out the channel.
Unblinking, so unblinking and eerily at times that it almost appears like the video is frozen. Just want to comment a little bit more on the physical appearance of Robinson, appearing over WebEx on video. Appears to be wearing what is described to me as a safety smock. We know he's on a special hold, right? They're going to hold him there in a separate unit before they evaluate his mental health, before they put him in maybe a more different location, more general location. They do that as a matter of procedure, right? But it is sort of interesting. He did say,
all right, we back in the courthouse again.
There's one thing, which was his name, which was stated clearly and firmly. And again, I want to say gels was sort of what we saw in that exchange of text messages, because he's talking to his roommate who clearly appears to have no idea, the roommate, what is going on or that he is the suspected shooter. And yet he's sort of talking a TikTok of what he's done and why he's done it and admitting to do it, essentially shocking this roommate through these series of exchanges, which sort of gels with his physical appearance today. Obviously, we also heard during the hearing the Utah County following the course of action to introduce the death penalty as well. That was filed as this was being read in court. So definitely some developments here today. And just the amount of information that we got, the blanks that were filled in. That's right. Not only that, but also on the apprehension, the involvement of the mother as well, and sort of bringing him in. And also the physical evidence, the DNA found on the actual trigger of the rifle, which was tied to not only what was found on the screwdriver, but also the towel used to wrap the rifle. So an extraordinary amount of information that we got, especially with this charging document.
So DNA was found on the rifle that belonged to Tyler, allegedly. They also saying that Charlie Kirk's wife, Erica, has got a protective order, guys. She's been receiving threats. She's got a protective order.
According to what the state had laid out in this text exchange, almost seemed panicked when describing trying to go back to retrieve the rifle that he allegedly shot Charlie Kirk with, not being able to do so when essentially caught out by his parents, when his parents approached him and said, we think this may have been you, tried to get in touch with him, tried to reach out. The state says that Robinson suggested or implied that he may try to take his own life here. So you can get a sense of his mindset, at least based on some of these text exchanges and what law enforcement has laid out over the course of some of these documents here. All of it, as we should note, these are the state charges here. It's possible federal charges could come.
Federal charges.
Yeah, federal charges possible. One notable sort of omission is we didn't see any federal officials. We don't know if federal charges will be filed, although it's heavily implied that they will. One thing also is sort of the level of deceit, both with the parents. The father did something that sounded very clever. It was heard the description of the rifle that had been described by authorities, federal authorities, state authorities, and that he assumed, obviously with the pictures of Robinson himself on camera at the university, assuming this is his son, try to get in contact with his son, trying to ask, hey, could you send me a picture of the rifle that I gave you? And of course, the son sort of ghosting him, seeming to imply, again, involvement. And also about the rifle, there was a lot of investigative work to try to figure out Was the rifle traceable? Was it bought legally, illegally? Would have been hard to trace, we now know, because this was essentially a family heirloom, something that's common in hunting families, passed down from grandfather to father to son, and that was the case here. So again, much more stark relief that we're seeing this case in the past.
If you have not double tapped that screen, double tap the screen, guys. That's how you hit the like button. Charlie Kirk, unalive.
You're going to stand by for us
In court
later on as we
live.
get potentially
Tyler
more
Robinson,
on
guys.
this. Danielle, let me go back to you here briefly because Steve laid out what could come next here. Obviously, the death penalty that the state is seeking. What about this protective order for Erica Kirk? Is that something that is typical in the course of an investigation?
Erica
like
Kirk
this,
gets a
prosecution like this?
protective order, guys.
Sure, yes. As to prospective victims, it's usually not entered against someone's spouse, but it makes sense here because this is not some street crime or a crime of passion. This is someone who was apparently, whether by this defendant or not, targeted. And so it makes sense to say, well, close members of the family may also be targeted as well. So it's not unusual for judges to enter those kinds of protective orders as sua sponte on their own or in response to a request from the prosecution.
Danny Savalos, thank you very much for that. I appreciate that. We have been talking now about the developing news that has occurred over the course of the last several hours with prosecutors laying out in detail how they say Tyler Robinson carried out this murder. We're going to play a big portion of that in case you missed it earlier. We want to basically roll that tape so you can hear for yourself how the state laid this out. Take a listen.
These are the allegations.
And let me stop it right here. At this point, does she play essentially the entire press conference by Mr. Gray?
Yes.
Okay. And we didn't include the entire 27, 30, or 45 minutes, right? We clipped it to get to the end of the coverage.
On September 10th, 2025.
From the courts, I'm guessing from Tyler.
12:23 p.m. Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action 30-06 rifle, nearby. Over the next approximately 33 hours, police conducted a manhunt for the shooter until the evening of September 11th, 2025, when Tyler James Robinson surrendered to police at the Washington County Sheriff's Office.
You have been listening to Jeff Gray, the Utah County Attorney, earlier laying out those minute-by-minute details on how they caught the man accused of assassinating Charlie Kirk. You saw the court hearing for suspect Tyler Robinson live before that. That was that virtual hearing. As prosecutors say, they will seek the death penalty. Robinson will remain in jail, no possibility of bail. He'll be in court again in just about 2 weeks.
And again, just to reiterate, we cut 27 minutes out of the press conference, right?
Yes.
So how does this coverage line up with what was happening in court?
Well, I think, like we said, there's an implication that there was, like, the text messages were part of the court hearings because he implies that was part of the hearing. And then it's bringing up all of this new information or old information that has nothing to do with the hearing. So it's just rehashing. Let's remind you about the text messages, DNA, the deceit of the dad because he was suspicious of him in terms of the gun, and all of these things have nothing to do with this hearing.
I noticed the reporter when he put that graphic up of the text. By the way, was that graphic the actual phone of Mr. Robinson?
It's not. No, and it implies, and then you see that throughout a lot of the coverage, like text messages. There's YouTube reels where somebody like creates a reel and reproduces text messaging, so it looks like it's the real text message.
And when he's putting that up there, he says, as we heard in the hearing, words to that effect.
Yes.
But there was no mention in the hearing of text messages or anything else, was there?
Correct.
Is he confusing what he heard in the press conference with what he thought he heard in the hearing?
Well, I think he's confusing the viewers with what happened in terms of now
We're back in the
viewers believe,
courtroom.
like, evidence is being presented in these hearings that imply guilt when that's just not the case.
So as you say in your slide, is this coverage sort of advancing the prosecution narrative as opposed to an educational function?
Yes.
All right. Did you also take a look at ABC's coverage?
Yes.
And by the way, the last slide was, I think, the longest slide, right?
I think so.
All right. So this is the same day
To thank all parties for being here, and this concludes this hearing at this time. Court is in recess.
All right.
So the suspected shooter there of Charlie Kirk, the hearing has now just concluded. We know that the state is pursuing the death penalty here. We have just learned throughout this proceeding that they are going to try to find him counsel. They deemed he is indigent, so they will be providing an attorney for the alleged shooter. And the next time that he will make a court appearance will be September 29th. And then again, as you heard the judge there say, that will happen on WebEx. A couple other things that we learned here throughout this quick hearing is that he will remain in custody without bail, and that the state was also present there, and they asked for a protective order on behalf of Erica Kirk. Of course, that is Charlie Kirk's wife. A reminder to everybody that, yes, he was a conservative activist, but he was also a young husband and a young father of 2 children. And a protective order has been granted on behalf of Erica Kirk. I do want to bring in our ABC News Chief National Correspondent, Matt Gutman. He's in Spanish Fork, Utah, there for us. Matt, thank you here for being here with us. And so we just saw this proceeding play out. No surprise, right? This is not the proceeding in which this person would enter a plea. But Matt, prior to this, there was a lot of evidence that the prosecution sort of laid out for the public, including text messages, DNA, things like that, that they do plan to try to present to the judge to be admitted here in trial. But perhaps, Matt, you can just gauge for us, since you've been covering this now for so long. Tell me about your first reaction here in seeing Tyler Robinson sit down there, if you were able to see it, sitting down in this court hearing.
He was sitting down. It was via WebEx, so he wasn't physically in the courtroom, Kana, with the judge. But you could see that people were watching. You can see he was wearing this padded vest, and that's because he's been in what's called special watch in this jail here, which is essentially in isolation. He's being held to prevent him from harming himself or from others harming him. We heard from the prosecutor earlier today in his announcement of the charges that the suspect's mother had said that he was suicidal and that he wanted to kill himself allegedly before, instead of turning himself in. So you see him in that protective garb. The bulk of this hearing that we just saw was the judge reading the 7 charges. Of course, they are aggravated by the fact that the suspect allegedly committed this political assassination of Charlie Kirk in full view of children. So that's one of the things that has enhanced the charges against them, and one of the things that makes this a capital case, according to prosecutors here.
And I'm hoping we can just quickly go through some of those text messages that you mentioned there, again, with this roommate, with who prosecutors say that he was romantically involved with. And one thing they touched on in this hearing too, Matt, is the fact that in this text message exchange, we're showing some of it, but Matt, they pointed out to the fact that they believe the shooter asked his roommate to delete the exchange and then to not speak with the media, and then it's shown in these charging documents, Matt.
Yeah, we have not seen these text messages. We have heard them for the first time from the prosecutor. They also put out this charging document in which these messages were revealed. And it appears to show this exchange between the suspect and his roommate, with whom he was romantically involved, apparently. And it's very, very detailed. And in the text messages, the prosecutor says that the suspect was talking about the murder weapon, talking about where he stashed it, talking about how he stashed it, and yes, allegedly advising his roommate to delete the messages and not to cooperate with law enforcement, to get a lawyer and not talk to the media if this blows up. And eventually it did. What also struck me about these messages, at least initially, is that the suspect appeared to think that he could get away with this. He was hoping that he would never have.
All right, so we got Turning Point USA, guys. They're actually doing the event right now. Let's teleport over there and see what they have going on, guys. Shout out to everybody in the building. Continue to double tap their screen.
Miss Charlie and everything he brought to this world, and we're grateful, Erica, for your strength to carry on. One of the things that
Something just happened. I don't know what it was. Hold on. Is it them or me?
Independence, but for to spread the
It might
strength
be.
to carry on. One of the things that Charlie.
It might be me. I don't know. Here, let me refresh it real quick. Hold on, y'all.
strength to carry on. One of the things that Charlie...
Is it them or me? It keep on stopping in the same spot. Hold up.
Her strength to carry on. One of the things that Charlie...
Let me close some of these tabs. Hold up, guys. Let me make sure it ain't me. Hold up. We most definitely got Turning Point USA on the menu, guys. Trying to see what's going on with it.
Strength to carry on. One of the things that Charlie...
And it keeps stopping at the same spot. I wonder if it's mine or is it this? Hold on.
Her strength to carry on. One of the things that Charlie...
It keeps, okay, it quit on its own. It wasn't me. Something happened. They took it off air, guys. Oh, wow. It ended right in the middle of it. Here, we'll catch some of what we missed, and maybe they'll bring it back. But it ended right
yesterday that he was going to
right as they
open
talking.
a new grocery store, right? It only costs $30 million, and it's going to be done in 2029. That's president. You know, they let it in 20. Think about this too. Abigail Spanberger, the governor of Virginia, she ran as a moderate. You're going to hear this a lot coming up in this election. She ran as a moderate. Now she's governing as an absolute liberal. They just passed a law that they're going to take the electoral votes in Virginia, not give them to the people of Virginia voted for. They're going to give them to whoever the popular vote is. So what's the Democrats' plan? Well, they let in 10 to 20 million illegals. You know, they want to try to win the presidency, the House and the Senate back. Then they are going to get rid of the filibuster. They're going to stack the Supreme Court. These are all things they've said they're going to do. And then they're going to give amnesty to those 10 to 20 million, and then they're going to have a voter bloc that can never be defeated. We have to stand up against that. We cannot allow that to happen. This election, the whole reason I'm running in this race, and the president asked me to run in CD1, and the reason he endorsed me is because this seat is so important. We have to keep this seat. There's 3 to 5 seats in the country that Democrats know we can go, we can try to flip.
Right. It's just, here's the text message.
Then they're going to win the House. This seat is one of those. Juan Ciscomani's seat in Tucson is one of those. We have to make sure that we're supporting Juan and keep him in office. We have to make sure that we get Katie Hobbs out of the governor's house and put Andy Biggs in. We are a center-right state, and we need to get back to where we belong. It starts with us, though. We have to have the right people running, people that truly want to be the representative of their constituents, that want to go there to serve the people. That's why I wanted to get in office, not to enrich myself like so many people in Congress, but to serve the people of this state. You know, when I think about Charlie Kirk and I think about his legacy, Rebecca and I were in the White House walking out as we found out about Charlie Kirk. And we were both gutted, like all of you were. She burst into tears, and we laid in bed that night. And she looked at me, she said, "Are you sure you want to do this?" And I said, "I have more resolve now than I ever have. I know God has put me at this place, at this time, for this reason." We need fighters. Our president is a fighter. When he stood up, when he took a bullet, and he stood up and he yelled, "Fight," that's the gutsiest thing I've ever seen in my entire life. Every one of you needs to stand up and fight. I need to stand up and fight. I'm going to fight for you, and that's why we're going to win this seat. Thank you so much.
I don't need no music. Build the red wall. That was a long break.
Sheriff Joe might be the guy that gets the most applause in this place, I think. Folks, 10 years ago to this year, 10 years ago in 2016, we had a businessman come down the escalator. A man who wasn't a politician, a man who represented what the average American was thinking, who said the things what a lot of Americans were thinking. And he jumped into that political race, took all the political arrows. And what was the slogan that he used that really mobilized Americans across this country? Make America great. And also build the what? Build the wall. That man went into office, and immediately we saw the benefit of having a president who believed in border security and in building the wall. He got to work. He built that wall. And for 4 years, we had the best years in law enforcement that we had had as it relates to border security, drug trafficking, human trafficking. Unfortunately, that story changed in 2020. Boo is right. Boo is right. The Joe Biden administration came in, and immediately, overnight, we started seeing hundreds of thousands of people, tens of thousands, many thousand coming in a day, sometime exceeding 10,000 people a day. The majority of these men were military-age men from all over the world coming into this country. Many of them didn't love America. And we stood by as our government gave, not only allowed them to come in, but rolled out the red carpet for people that broke our law and came into this country illegally. They stopped building the wall like President Trump had said, what was working. They immediately just gave up and started letting people in. Now what do we have? Crime against Americans. We have fraud from people that probably shouldn't be in this country. We have abuse of our welfare systems. The list goes on and on and on of the problems that precipitated by opening the border and by not finishing building the wall. We're not any different today, although we have a different proverbial wall. We have got to build a red wall in this state and in this country. I think all of us are sick of crime, and President Trump's administration has reduced a lot of crime, but every day we see more and more crime perpetrated by people that are in this country that should have never have been in this country. The previous administration, folks, they let the wolves inside the house. And now we've got to do the best we can to get these wolves out of the house and build a wall so that this never happens again to America and the American people. As you know, I like history. So I was looking, what hit story can I tell from history talking about building a wall? And I found the story of Ticonderoga, which is a fort way back then. The English used it, conquered it against the French. And in 1775, two men, along with a lot of extra soldiers, Ethan Allen, not the furniture guy, and another guy who was a revered war hero at that time, Benedict Arnold. Right? We know him as the traitor. But before that, he was a revered war hero. They took Ticonderoga back and held that fort for 2 years. But eventually, we got weakened. We got weakened along there. We couldn't staff it. We didn't have enough watchmen on the tower of that fort. And in 1777, we lost that fort. It became inconsequential throughout the rest of the war. But that was how important having those walls and fortresses were. And eventually, we ended up losing it because we couldn't stand together. They didn't have enough people to stand together. We need now more than ever to build a red wall in this country, in this state. And that wall, the foundation of that wall, should be God and the Constitution. That is the foundation. And every one of you in here tonight, you'll see some of us up on the stage, but every one of you in here needs to be a piece in that wall, a brick in that wall, a patriot. I would love to be a watchman on the tower for you in Washington, D.C. For you. The sheriff can attest to this. People would say to me, I would critique the government, and people would say, well, Sheriff, you're the government. And I'd say, no, I am your county sheriff. My job is to protect you from the bad guys and from government overreach. I will take that same mentality to Washington, D.C. to protect you, the American people, from increasing government overreach. For those of you who know me, you know my wife is much better than me. I tried to convince her to run for Congress. But I was getting ready today, and my wife and I were talking about things, and she brought up a quote, and I love it, and I want to share with you today. She said, if not now, when? And if not you, who? And everybody that's going to walk up on this stage understands that now is the time. And you have to be part of it. I'm going to tell you a story of patriotism, because not only will you be the bricks in the wall, but this country was built on men and women who had a desire, an insatiable love and desire for freedom. So much so that they all got together and they penned their name on the Declaration of Independence, knowing that if they failed, that would be a certain death warrant for those men who signed that declaration. But with courage and with a belief in God that they could achieve freedom, they put their names and their signatures on that letter and sent it to the most powerful country in the world. One of those men who signed that Declaration of Independence was a...
All right, guys, I guess this is a good stopping point. Here in about an hour, 4 o'clock Central Standard Time, I'm going to come back with Trump and basically Erica Kirk speaking at the situation at Turning Point USA. So if you're not subscribed to the channel, make sure you subscribe to the channel. Turn your notification bell on to all, because you don't want to miss anything whenever everything news goes live. At 4 o'clock, I'll be back with Erica Kirk, and Donald Trump, man. You know, he's going to give a speech at Turning Point USA where we were just watching. But we most definitely covered what was going on with Tyler Robinson. You know, he had court today. Found out that it's some kind of new messages that have came out, so be looking forward to that. And also finding out that Erica Kirk basically has got a protective order, I'm guessing, from him. So Turning Point USA has a event going on. Trump gonna speak in an hour. I'm gonna grab me something to eat, man. We'll come back. Make sure, like I said, you subscribe, turn your notification bell on to all. You don't want to miss it next time I go live. Shout out to everybody in the building, man. I appreciate each and every one of y'all. I'll see y'all in about an hour. Subscribe to the channel, guys.